We're live. Hello. How is everybody doing this evening on this Friday, September 20th? So tonight we're going to, I don't know what we're going to do. We have no plans. I'm just kidding. We have plans. And we also have Boo.
Oh, that was fast.
Yeah, I know. I'm going to say hi to all my friends, okay? So we've got Miku. Hi, Miku. I missed you the other night. Zero Cool is here. Hi, Jojo. Miku says, I'm working on a marketing assignment. It's due at midnight. Oh, God. I have to have you on. My group is stupid. There's this like funny meme or whatever. It's like, when I die, I want my group project to lower my casket into the ground so they can let me down one last time. Have you ever heard that? I hate group projects. They're my nightmare. Dean, how do you feel about group projects?
I mean, it depends on who's in the group, I think.
We could argue this is a group project.
We could argue that, which, like, this is a fine group project because you do all the work and I just kind of tag along.
Get out of here. Hi, Untamable. Trader. Yeah, I was trying to read the chat earlier. Miku says, I'm doom and gloom today because a 14-year-old got sentenced to life without parole. I keep seeing that case popping up on like my Twitter feed and YouTube, and I know that I'm gonna get really fixated on it, so I haven't actually really allowed myself to dive too deep into it. Do you know what case they're talking about, Fiend? That like 14-year-old?
I mean, I've seen like very surface level stuff. I mean, she's kind of on video just committing the murder, so it's not like a. Well,
was she like deemed incompetent at one point? I don't know anything about it.
So. I don't know about that, but
got it.
I know she did it.
Yeah, that's hard. Miku says mentally ill child, the state expert said was rehabilitatable. Life without parole. Yeah, I'm not a fan of that for juveniles. I don't know. I don't see the harm in like leaving the possibility open, you know? But I digress. Judy, this is the nicest comment. Judy Northern Johnson says, I'm always here in the background. I don't say in chat, but I'm tuned in and supporting you and DB Yellow Jacket, All Eyes, and others, including you, Fiend. You're others. Who else? There's my wife. Hi.
We call that a lurker.
A lurker. I like to lurk. I think lurking is safe. You know, sometimes lurking.
Hello, everybody.
Oh my gosh. Hello.
I heard somebody said hi and they're a fan of somebody, and I just decided to show up.
Welcome. You look very handsome. You both look very handsome tonight.
Hey.
What can I say? I'm more handsome than Fiend for sure.
Very dashing. Hi, Christine.
Don't know about that.
Been a long day. She says, hello, Ange, Fiend, Yellow DB, and anyone else I forgot. She got the whole motley crew in there. Hi, Pebbles. DB wants to know how long Pop-Tarts will last. It depends. Last in what context? Like, how long will they be a solid?
Oh, I don't know. That's a message from yesterday. Got
it. Hi, Sleuthy.
I thought it was how long you could like live off of a Pop-Tart.
How's long to die in a Pop-Tart?
Hi, Luke. Oh, hi, Dean.
Dean is the homie. Hi, Heather Brown. Hi to all the moms out there, my friends.
Already with the moms?
Well, I got to get them going early.
We're starting early tonight. Hi, Hammy. Royal Wheat. Kokomo. My buddy. I was walking the dog, but I had to reset my router, and then I was like, I might as well walk the dog. It was a whole thing. Look.
Reset your route. Don't laugh at Luke. And next.
I didn't laugh at Luke. I laughed at what Luke said. There's me.
That just encourages them.
I know. Hi, Kel. There's a woman doing all the things. Linda K, my love.
And I wanted to say in person here, now that we can all see each other face to face.
Sure.
I made the decision on my channel here to promote woman, chick or woman doing whatever the fuck, right?
Yeah.
Whatever her name is.
Sure.
You know, she's yeah, we just had too many guys doing the mod stuff. So we got a letter from the ACLU and they just told us we had to pick somebody, and her name's Woman. So
they were kind of miffed.
They were pushy.
Yeah. Makes sense. Makes sense.
The good thing about Woman is that she's got woman in the name, so it's very clear that we're meeting the
That's the point.
Hi, Heather. I'm almost done here.
And we talked about group projects. It's good to have some female mods since they can do the work.
True. Hi, Christine Beck. We got all our Christines. Great hair. I think he's talking about you, Fiend.
Thank you.
Oh, or you,
Oh.
DB. I don't know which one. Y'all can duke it out. Hi, Estrella. I've been at the courthouse all day. Still got business to attend. Catch you later. Redneck he's cool because he'll come in, he'll hang out for a minute or two, and then he'll be like, I gotta go see about a girl, and then he'll dip. You know, I like it.
Dude, Redneck pulls chicks, bro.
He pulls.
And he presses the refresh button.
Mm-hmm.
Hey guys, everybody, right now, press the refresh button 5 times. We need views.
Why? I'm not.
We need views.
What does that do?
It gives us more views.
Does it?
They're gonna clip that, and then I'm
God.
gonna get accusations, new accusations.
I'm gonna get Accutane. I have pimples.
Accutane's rough. We'll talk about Accutane another time. Hey, Owl on the Prowl. Chelsea's here. I love Chelsea. Hi, Chelsea. We got a lot of really beautiful, cool friends, you know, and smart, and so smart.
Dark. Never mind. I'm not gonna say dark webby Peggy, but yeah, I just did say it. Fuck.
Trav says, "Oh boy, I had to fill out a quiz to get in. I failed 5 times. The 6th time was a charm." Was it one of those like captcha?
No, it was like a affidavit that you had to agree to.
You have to sign in his blood.
Yeah, it was like the rules, the terms and conditions of being in the chat. I was also taken aback by that.
I'm so sorry about that. I don't know why I made you do that. I had nothing to do with it. Don't blame me. Hi, True Crime Fangirl, Thomas Scott. Okay, I think we're about done now. And if I missed you, I'm so sorry. Pop Tarty's here. Okay, you said Pop Tarts earlier, and I was thinking, oh my gosh, I miss Pop Tarty. And look, you summoned her like Beetlejuice.
Dude, she rules. I miss her.
Huh?
She rules. I miss her.
Yeah, she does rule. Hi, Sleuthy. There are no rules in here.
Fucking word clouds, dude.
Okay. So, this evening, are you reading, DB?
Yeah, I'm reading the chat. What are you talking about?
Are you going to be, do I need to contact the understudy, or are you good to go?
No, the understudy's here.
You're the understudy?
No.
Who's the understudy?
I'm a different character, dude.
Fiend is my understudy.
Maybe we can get Trav in here. Well, there's 3 parts, man. If you can't do it, we can get Trav in here. It's up to you.
Well, what about me? I can be the 3rd part.
I'll just change my voice like
I tell you what, Angela is
Yes.
a bitch.
Jeez.
Angela, this is what you're doing.
Okay, too far. I'm gonna get us attacked. My bad.
that's not even the worst thing I've heard today. That's actually one of the kinder things.
I've actually, you know what? I wanted to clear up a rumor I heard.
Oh, great. I can't wait.
There's been some speculation, and I didn't know this, and I've done like 15 background checks on you. So like,
I know. Yeah. What?
what'd
you find?
I heard this about you, and I just wanted to say there's a.
I was gonna do a background check, but I couldn't figure out.
Go ahead.
I couldn't spell the last name, so
Mine?
I gave up. Yeah.
Hey, Fiend, what sentence ends with "I was gonna"? Anyways,
Yeah.
I was gonna mention this, and I'm just gonna come right out with it. I didn't know you were paralegal.
Me? Yeah, I'm a paralegal. I went to Duke Law School. I got my paralegal degree.
You're fucking exposed, dude.
Yeah.
How does it feel to get exposed like that? Something
I feel pretty exposed.
Oh my god, what? I didn't know that, and that came out, and like
I told you that today, I think. Well, no, you knew. You just didn't. You thought I went for what?
I think it was like
design. What'd you think I went for?
Interior design or introduction to walking around.
Yeah.
Something like that. Yeah.
Dog walking.
Dog walking. Introduction to touching your hair until it, drives your.
Touching your hair until you wind up on a Delphi YouTube channel for 2 years.
I don't know anything about that. There's layers, yeah. So we do a thing. It's like a whole thing. We do like a whole thing. It's like a thing. People like it. Some people like it. Some people hate it. Pancakes. Anyway.
Chocolate pancakes.
Get the cranks to trial fund. Yes. Thank you so much, Yellow. I just love it. I can't wait to send you a $4.99 coffee in about 10 minutes. We'll just, like I said, we go back and forth until we die is what we're going to do. Travis says, doing trigger, we have a new puppy. Oh my God, what kind of puppy, Travis? The kind that pees. Sounds like a puppy. Are we ready to go? DB, did you finish your thought?
No, I think Fiend interrupted me. What was it?
I don't know. You were saying that you wanted to clear up something.
Yeah, I heard that rumor that some news came out about you.
Yeah.
And that was really titillating for me.
Titillating news or nudes?
Well, I've heard both,
right.
To be honest, but I just was touching on the first one.
News. Okay. Yeah. Both.
I just thought that was interesting, and come to find out, you went to a prestigious school, and that's reprehensible, really. But
I know.
We can move on.
Yeah, I know. I don't like to. I don't know what I'm talking about. The titillating nudes. Okay, so to start, I don't know. I don't think this will take like that long, but
Hey, Fiend, how was your day? Fiend, what'd you get up to this week, huh?
This week?
Yeah, what's been up, dude?
Not much. Chilling.
Oh, okay. Just checking in. Yeah. Okay, my bad. Go ahead.
You done? Are you done?
Yeah.
Fiend looks like he's had a fine week. Fiend, you look like you're relaxed. Okay. So we're gonna go back to. I'm so glad Travis is here for this. We're going to go back to the Jennifer Dean trial, but this time tonight, instead of we're going to bounce around to pre-voir dire. This is a interaction between Judge Diener and Prosecutor McClelland and defense attorney Pat Manahan. Any final words? I'm going to share it in a second.
Yeah, what page are we on?
We're going to start at page 1, I think. I'm pretty sure we're right smack at the beginning. DB, do you need this? You have this.
Yeah, I need it. I lost my link.
Okay.
Wait, are we on a different PDF now?
No. This is same one. Volume 2 of 7. Page whatever page this is, 4. Do you need the link again, Fiend?
No, I've got the link. I just need the page number.
It looks like PDF page 4, transcript page 2-4.
Oh, are we going backwards then?
We're going backwards. We're starting at the very beginning.
Gotcha.
Pre-voir dire.
That's the part that confused me. I usually only move forward.
Yeah, we do things differently here, Fiend. We like to go backwards. We like to, instead of progress, we like to, what's the opposite of progress?
Devolve.
Anyway, that's that, Duke Law. So let's
hold on. I just got to bring this up real quick. Did anybody see Luke's picture?
Of what? Regress. Thank you, Travis.
Of his haircut.
His haircut, no.
Oh, you stop what you're doing. Everybody go to Twitter.
Hi, Montana. Luke, did we have your...
X?
Look who's here. Leonard. Hi, Amber.
God.
Miss you. So nice to see you. Digress, regress. Hi, Montana girl.
What about pregress?
Sure. Whose haircut? Luke, do we have your consent for Fiend to show your haircut?
Fiend doesn't know how to show anything. He's on mobile, dude.
That is correct.
Okay.
Did
Well,
you figure out the alt codes?
What do you want me to do?
Yeah, I sent you the link, or I tagged you in it in the post.
Okay.
I had all the alts. I could change my profile pic to Luke.
It's okay. I can share it if I have Luke's consent. But he hasn't answered. He
says brace. That's the correct instruction.
Oh my god.
What?
This
What,
handsome-
sir?
This guy, dude.
Hi, Peggy. How is Ange? Ange is great.
Yo, get Peggy up here. Peggy, get the fuck up
Hi,
here.
Peggy. Oh yeah, Luke. Hold on. Let me get. How do I get That's what the fuck I'm talking about. Share screen. Oh, wait, I'm not even in the. There's two of me now. Look at that. Share screen. Make sure the DMs are not.
Oh god, please don't.
Man, how you like that? Looking good, Luke. Is it like totally shaved? Is it pulled back? It's shaved. It's a shaved head. I like it. I give it a 10 out of 10. What do y'all think? Chat? Drop a 1 in the chat if you think Luke looks fine AF. Go ahead. Don't be shy. Is that a before and after picture? It says. I don't think so. Look at all the 1s in the chat. Okay. Wrong person, wrong poll. Okay, are we? Is that good, Fiend? Is that what you want to do? Did I do it? Are we good? Am I okay? I'm okay.
No, I didn't say you show it. I just told her to go look for themselves.
You didn't?
You just took it to the next level.
Well, shit.
Yeah, you just
Right.
got.
I guess you're right. You didn't actually. Oh, wait. Okay. I got confused there for a second. Let's go, because I'm told that I dilly-dally too much sometimes on lives. So let's start reading, and then we can dilly-dally a little after.
DB's an absolute fucking idiot.
Who can't fold a burrito.
Who's reading?
Okay, let's go.
Luke.
So I think you can pick. I like when you're
It's
McClellan.
Luke.
It makes me happy.
Okay, I do have the mustache, so that works.
I really like when you're McClellan. DB, you want to be Diener? I think he has. I don't know who talks more, man.
Thank God DB's not here.
Oh, okay. Luke in his British accent. Luke, do you want to?
I'm absolutely gutted, and DB's an idiot. But
Oh my god, I just turned Russian a little bit. My bad,
I
dude.
don't know what that was. It was.
Oh, dude. I
was
can't give this guy
eclectic.
more ammo. I gotta get back. To when I need to be here. Oh my god, I got so many identities.
Is
Which
that
fucking one am I gonna be?
Harshman's?
No.
That was it.
What?
You got a lot of handlers.
Oh god.
My word. My word. Did I go potty? Oh, earlier, yeah. I went potty. I walked the dog. We both did. We're good.
Wait, who am I? The Diener?
All right. Ready? So this is jury trial, April 18th, 2022. Are you McClellan? Are you Diener, DB?
Mm-hmm.
Is that a yes? Okay. Whenever
Yeah, I'm
you're
working on Diener real quick. Sec.
Oh, okay. Dean, what'd you think about that Weircat full blood moon the other night?
It was pretty crazy. The moon was. It wasn't quite full yesterday, but it was very bloody.
It was super bloody, bloodlusty.
Mm-hmm.
Love that. Tomato Tony Liggett is my favorite DB alt so far. Love that. Do y'all know the trick to getting an avocado core out? You just smack it with the sharp end of the knife.
Oh, okay.
And then you.
I was gonna say hammer, but that's
or hammer.
Probably wrong.
Hammer works too. My hair was between my shoulder blades. Love that.
I too once had long hair, or not once, many times I've had long hair.
You're assuming identities, and I would just like the record to show that I am not the handler of this man. He is his own handler, and I want qualified immunity.
Because you're a cop. I can't find my Diener picture. What are they doing with that?
I'm a cop feed. We're learning a lot of things about me today.
DB, you gotta make sure Diener has the Luke haircut.
Where's my fucking...
Don't tempt me with a Photoshop.
No, you don't even need a Photoshop because right after Judge Diener recused himself, he shaved his head and his beard.
Why? Remember? Yeah, let's talk about that. What's up with that?
I don't know. Do you want a bald Diener picture?
No, I'm making one right now instead of just coming prepared to the live broadcast.
Yeah, no pressure. I mean, you know.
Yeah, it's my channel, you know, do what I want. It's kind of my thing.
Will Nick get a haircut before trial? Who knows? Will he shave his mustache is the question.
Maybe he'll get like cornrows or
like James Franco in that movie.
Right, yeah, exactly.
He kind of, I mean, there is a resemblance there.
I mean, he's already got the shell necklace, right?
He got a puka shell necklace?
Yeah, he does.
That's fucking fire, dude. I take everything back.
Yeah, that's pretty badass, actually.
Spring break. Oh, get it? Because it's cornrows, spring break. I get it. It's pretty funny. It's layered. That's layered, you know. Trev said, avocado seed removal is the best with an ice pick. Jam pick into seed, not too hard, not too soft. With authority. Rock seed back and forth, pop out. Yeah, that's what I'm saying. An ice pick is a
murder weapon.
Versatile tool.
An interesting tool. I was just going to say the sharp end of a knife, but an ice pick probably is very effective. Answer my question up there. Okay, let me find it. I was wondering about your full moon. Do you mean my butt? Is that what you mean? Is that a butt? Is that a butt joke? What do you think that means?
Oh my.
Or does it just mean the full moon? Because either way, I'm happy to answer. And ask my question. Oh, wait, here it is. My bad. Can you please give us your background? I'm curious to know. Master's thesis. So I did a whole thing on it. Sorry, I answered the wrong one. Yeah, the lore is a lot less interesting than it's, being made out to be. I went to Duke Law School. I got my paralegal degree after I got my undergrad, and then I went to UNC and I got my master's in social work, and then I was doing research, and that's how I ended up in this purgatory called the Delphi case, where all of us are hanging out right now. There's a longer version of that. I'll tell you some other time. No one's talking about your butt, hun.
Well, now I want to know DB's background.
Where is DB? Speaking of which, are you all set, sir?
I told you I'm in Bahrain. I was doing a weapons deal, but now I'm back. My background is started out at West Point. Was on the football team. Wrestled in high school. 4.0. 4.0 in college. I'm 5.4.0 in real life, and yeah. graduated top of my class of Chipotle burrito making art school, and here I am. I'm from parts unknown.
That's impressive.
I know.
Compared to Ange, you know.
Yeah, I mean, if I wanted to go to a little blue blood school, you know, it would have just opened the door.
Too bad. Too bad. DB is so baby girl. Can we start?
1 second.
God.
1 second. When I used to do public affairs for the Department of Defense and Raytheon, they taught me to make sure that your profile pictures are centered properly. So when you want to really change the narrative,
that is not centered.
It's properly. Like a BDI. It's like a Diener BDI inside of a Diener BDI.
Yeah.
You know?
Yeah, I do know. That's what I was going for. So I appreciate that. You guys can start, or is Diener first, or can you guys?
You're first, sir.
No. Ange, maybe you should just be Diener.
I'll be Diener. Let's go on the record. This is case number whatever. Caption: State of Indiana v. Jennifer L. Dean. Miss Dean appears in person in the custody of the Sheriff of Carroll County on an unrelated matter, but in civilian attire, etc.
Are you seriously going to read my part?
Do you object?
Okay, here I go.
Okay.
Okay, where are we at?
Very beginning. Take it from the top.
The court. I'm not supposed to read that part. I'm sorry. Let's go on the record. This is case number. I'm not saying that. Captions of the Indianas versus Jennifer Dean. Miss Dean appears in person in custody of the Sheriff of Carroll County on an unrelated manner, but in civilian attire. Luke, any help with that one? Terra, and by counsel Patrick F. Manahan. The state of Indiana appears by prosecuting attorney Nicholas C. McClelland. We are presently outside of the presence of all prospective jurors. This matter is scheduled today for trial by jury, scheduled to begin, and I believe it's 9 a.m. It's approximately 10 till 10 a.m. The prospective jurors have viewed the instructional video, and the parties have met in chambers, and it is customary to set the table as to what the anticipated procedure and or pretrial matters will be. And as gentlemen, we're fairly apprised as to what is going on now. However, it will involve a fair bit of legal argument. It is a trial and discussion, and so we'll turn over to the parties here shortly. They didn't do the next person reads the next paragraph at Duke. Okay, I'll take the next paragraph too. There have been some pretrial notices filed with the court from the state's perspective regarding the anticipated evidence, and there have been supplemental witnesses listed, filed, and we're now here, ostensibly for trial. However, there are pretrial motions that the parties have indicated may wish to make at this time. Let's start with counsel for the defendant, Mr. Manahan. In chambers, you indicated a very high likelihood of procedural and or substantive motions that would need to be addressed prior to the commencement of trial. Do you have any such motions at this time?
Mr. Manahan.
I'm so sorry. I was muted. I was going to say, can I make a comment before I get into character? He speaks the way that one would read, he said etc. aloud, and he also said and or. It's just he's very long-winded, isn't he?
Okay. Yeah, I get that from talking out loud at the words that he is quoted with saying here. I do feel a bit long-winded. Yeah, my mouth is dry now. It was kind of long. He must not have salivary glands.
He doesn't. He really doesn't. It's a known fact.
He just needs a spray bottle. He just spray it in his mouth.
He sprays his eyeballs in his fucking mouth.
Such an unsettling image. Okay. All right. I'm in character now. Mr. Manahan. Oh, wait, that's me. Judge, at this time, I would move to dismiss count 2. I mean, the state can proceed on the theory of count 2 that it's filed, but the state, as I understand it, is wanting to make that count 2 a conspiracy charge. And when the court looks at the statutory requirements for conspiracy, The charging information falls short because it does not allege in count 2 that there was in fact an agreement or overt act. And under the terms of the statute, it must be filed that way. And so what we have now is a count 2. It is not a conspiracy-based statute or charge. It's an act that was committed solely by the defendant in this case. And so we're here to proceed on the basis that count 2 is not a conspiracy charge because it's not been alleged. It is barred by the statute, and therefore the state should be bound to the conditions set forth in that charging information and not be permitted at this late date to amend the charge to include conspiracy. So again, it just kind of depends on where we're going. But the motion to dismiss is only premised upon the fact that the state may be seeking to amend count 2 to incorporate a conspiracy charge for those events, Judge. And so that's kind of where we're at now. I don't know what the state wants to do. If they want to amend, then there's an argument that I wish to make about amending at this point in time, Judge.
Oh, sorry, I was texting what was that guy's some guard from fucking Westville. Okay,
Wait,
thank you.
Sorry, hold on, because I'm told that nobody can see my screen share. Oh wait. Oh my gosh. I'm so sorry. That's annoying.
Press 1 in the chat if this is the most professional you've ever seen us operate.
Did that work, Sleuthy?
It'll get better when we get to my part.
Well, I just want to make sure everyone can see it. I don't know why it's not showing.
You know, when I think of Fiend, I say professionalism.
You can see it now. Okay, perfect. All right. Carry on. The court.
Court. Oh, yeah. Like I said, I was texting CEO Roberts. Thank you. There's been a motion to dismiss under the theory that Indiana Code 354152B provides as follows. The state must allege and prove that either the person or the persons whom he or she agreed perform an overt act in furtherance of the agreement to whisper, if you will. The motion alleges that count 2, which provides in relative part as follows, that between June 15th and June 21st in the county of Carroll, don't say it like that, the state of Indiana, Jennifer Dean, did knowingly or intentionally take U.S. currency from Willie Smith Jr., rest in peace, or presence of Willie Smith Jr. by using a force, a threat, using a force by hitting in the head, trigger warning with a bat, said act resulting in serious bodily injury, severe head trauma to Mr. Willie Smith Jr.
Mm-hmm.
Oh, that says Mr. McClellan as me talking to him.
Yeah, they
it's not all caps. God.
Yeah, they tricked you there.
Yeah, I have this condition where I can't read all caps. Okay. Mr. McClellan, does the state of Indiana wish to respond to the motion that is being made by the defense at this time?
Yes, Your Honor. Judge, the fundamental reason we have charging information is to put the defendant on notice what they're being accused of so that they can prepare for trial. The courts and all parties are strongly against trial by surprise, and that's why we have charging information entered, to put the defendant on notice. The defendant is on notice for what the theory of the state's theory of the case is. They've been on notice for some time. I think this is either the 4th or 5th time we've been here for a trial. And the defense is on notice, at least in part because of count 1 and the allegations that are alleged in count 1. And so the defendant, if there's a lack of the charging information, the defendant's not surprised or not put on notice what the theory of the state's case is. I'll draw this court to just a few cases that we found. Again, this was just brought to my attention this morning, and so I did a short search. It looks from the prior cases that the charging information, as the state's alleged, is sufficient. Starting way back in 1919, the Indiana Supreme Court, an indictment for conspiracy to solicit bribes, did not need to show overt acts done in pursuance of the conspiracy. That's Williams v. State. Move up to 1980, Brown v. State. A charge of conspiracy on indictment and information can only be so certain of particulars and enabled the accused, the court, and the jury to determine the crime for which the conviction is sought. In that Brown case, the court goes on to say we have been unable to locate any other authorities which require the defendant's role in the conspiracy or his or her intended part in the underlying offense to be alleged in the charging instrument. Move on up to 2005. A defect in charging information which admitted specific overt acts of conspiracy to commit murder did not constitute fundamental errors, since the information provides sufficient details to allow the defendant to prepare the defense. So, I think the state's given enough information. I don't think there's any surprise by the defendant on what the state's theory is or what the acts that were committed by the defendant, and so the state believes the charging information is sufficient. Judge.
Judge, in response, the statute's clear. The state must allege and prove that either the person or persons with whom she agreed to perform an overt act in furtherance of that agreement. The state must allege. There are cases that we would cite in support of that, Judge. The first one, Supreme Court case, it's Abner, Abner v. State, 497 Northeast 2nd District 550. Again, it sets forth the premise that the state is required to provide information so that we can prepare for trial. And we would submit to the court that there are all kinds of overt acts that they could allege. They could allege all kinds of things. They have not alleged any overt act, nor have they alleged any agreement. Fundamentally, under the statute, these two things are required. So at this time, I don't see how, in the reading of count 2, it's there. It alleges anything other than an act that was supposedly had been committed by my client, Miss Dean, Judge. So it wholly fails to meet the statutory requirements, Judge. And so again, we would ask the court to permit us to proceed to the trial with what's been filed.
Hi, I'm the court. That frames the issue more clearly. The court is likely inclined to allow the state to proceed to trial as the offenses are presently charged. However, the court would like to acknowledge that count 2 does appear to be procedurally defective if the state is attempting to pursue conspiracy as a theory. And so, at this juncture, I suppose the motion to dismiss is denied.
Interesting.
So at this juncture, I suppose the motion to dismiss the criminal charges is denied. Well, I guess that's a ruling. However, hey, actually, real quick, I'm not going to put the banner up for legal analysis. First of all, I liked the video. If you like the video so far, subscribe to this channel, my channel, and unsubscribe to
like, subscribe,
Fiend's channel.
unsubscribe, report, and then
the report Fiend.
Subscribe again.
And then refresh the browser.
Refresh the browser, yep, a couple times, and then yeah.
Okay. Okay, and then also Travis, what is the law? Okay, however, we may not substantially get too far down the road regarding the pursuit of proof of that case unless there is some proactive steps made by the state to address the procedural defect, at least to acknowledge within the standalone count of count 2 who the co-conspirators are and what any alleged overt act is. That was my question. Travis, what is an overt act? Luke, don't answer. I'm asking Travis. If that is the theory of the case that the state wishes to proceed, the record has not yet been identified, but the parties have been provided on today's date, and as the state referenced prior to earlier efforts at the trial, courts proposed preliminary instructions, and the court did make efforts and instruction to synthesize what it believed the appropriate theory to be of the case based on the publicly available information, such as the probable cause affidavit. But that required some synthesis to a degree that you can answer that one if you want, Luke. What is synthesis? To a degree that the court would take umbrage with as far as the defendant having appropriate notice. And so, for now, the state may proceed with the trial as pled. However, I would foresee strong issues with the conspiracy theory as charged. Okay, then what, Oh my God.
Then
what?
What?
Without? Okay. No, I'm not going to say the F word. I don't do that.
No, you don't.
unless you do, but without any motions to amend or anything at this juncture, the court will just be a creepy bald guy. Just notice that this is prepared to proceed with trial. Mr. Manahan, any further motions from the defense prior to introduction of the prospective jurors and a potential voir dire, if that is how the state is prepared to proceed?
Not on that. Not as to that issue, Judge. No. As long as we're proceeding as it's filed, then that's what we're prepared to do then, Judge.
So it's kind of a non-answer answer. The state has a position that it believes meets muster, and the court denied the motion to dismiss that the county has pled. But the court is acknowledging that there is likely crucial issues unless some action is taken by the state prior to trial. And so, Mr. McClelland, how does the state wish to proceed at this juncture? Is there any need for a recess, or are there any motions for the court prior to this proceeding? I call this a lifeline.
Well, Judge, from my perspective, it sounds like from the court's comments that a motion to amend is going to be necessary. And so I'm going to need to make that motion. But how I amend it, I'm not sure how to go forward, Judge. And so I need to ask for a recess in order to make that a motion to amend. It sounds like the court has said that I can go forward, but there's going to be issues. And I don't want to be directed. I don't want a directed verdict to affect the case in any way. And so I believe the state's going to need to make a motion to amend. But I'm not willing to do that in a hasty way. And so I'm going to need some time, Judge, to determine which is the best way to amend that so that doesn't add extra elements to the state to prove beyond a reasonable doubt.
My God. Weenie.
Did I say something wrong?
No.
That is fucking hilarious, Tommy, and I appreciate that. I understand that you feel a particular way about my voice, and that's nice. Yeah. Also, are you a T-ball coach or are you a judge? Because you're just setting up the fucking T-ball at that point, dude. You just told him that he had to fucking amend his shit. And then he was like, well, Judge, this is usually what you tell me what exactly I need to fucking amend to move forward.
It's almost like Judge Gold telling him to file a motion in limine.
You know what?
It's almost like he doesn't know how to do a prosecution.
Are you guys talking about me?
This is ex parte over here.
Okay.
Oh, yeah, it's me. Sorry. Tommy, be prepared. Understanding that and knowing we've got prospective jurors here in somewhat of limbo. Is that a legal term? Luke, should we instruct the prospective jurors to return today, potentially at 1 p.m. or something? It's 10 a.m. right now. That would be 11, 12, 3 hours. I know 3 hours is an extremely brief period of time in the scope of the law, but given all the factors at play, you want to know what else isn't? A fucking post-conviction relief hearing in motion. That takes a little bit longer than... Okay, never mind. But given the factors at play, that would be, I guess, the quickest way to see if we're able to address these issues and still not miss out on too much of the time allotted for trial this week. I'm willing to take other suggestions.
Judge, I don't know that I need that much time. I just need to go down and formulate a way. Again, the state's concern is that if I amend it in a way that's going to add additional burden on the state, and that's what I don't want to do, Judge. So if I had half an hour or so, I could probably get it done, Judge. But it may take longer than that. So I don't have a preference either way, but I don't think it will take me 3 hours.
Are you outside?
No, I just got my window open.
Oh, okay.
Sounds of nature.
Go ahead and close it. Thanks. Okay. The court is going to instruct prospective jurors to return today at 1 p.m. And the parties, meaning the process. What, am I in the wrong spot?
No, you're just such an asshole.
Me?
Go ahead and close it.
There's noise.
Okay.
I mean, this is our channel. It's not Fiend's channel.
It's just crickets, man.
That's a good point. I'm sorry.
I don't give a fuck what it is.
I'm going to mute
Okay.
myself.
You know what?
Okay.
You know what? I'm gonna keep reading, Fiend. And if I hear one more cricket, dude, okay. Excuse me. Meaning the prosecuting attorney and defense counsel, we may need to make further records. What was that?
We got cats. We got.
Was that a cricket?
Oh, it was a cat.
Was that a cricket? We may need to make further records outside. This is a really fucking weird 1-900 court record. We got animals. Okay, anyways. The royal we don't tell me to be nice. But hopefully I'm gonna get through this paragraph, guys. I swear. We may need to make further records outside of the presence of the prospective jurors prior to 1 p.m. But hopefully we will be able to begin promptly at 1 p.m. Excuse me. Within the introduction to the jurors, as far as the statements from the court and into voir dire, and with having any of these final pretrial matters resolved with clarity before then. So that will be the actions of the court. I understand the state may not need 3 hours, but that's going to be the swiftest way for the court to handle this issue with certainty. And so we'll reconvene with the presence of the jurors at the earliest 1 p.m. And the court will be available to the parties between now and 1 p.m. to help them write their motions.
Judge, before we go off the record, I know there's at least 2 jurors that I think are going to be struck for cause. Should we strike those now to release them from coming back? One has a pending case, and the other one I fully believe is still employed by the Carroll County Sheriff's Department, at least in a special deputy position.
Pause.
Who the fuck is that? Oh, I said the F word.
He said the court will be available to the parties between now and then to help you write your motion. Like, we'll be available to you between now. Like, is he writing the motions for him?
Okay.
One
thing
it's like, it's like when you have the TA like help you out.
Yeah, it's like a safekeeping order. He's gonna help. He's gonna TA.
Hey, speaking of the TA, I want to strike Royal Wee's comment from the record, please.
This one?
Well, you're the judge, so
that's what I'm saying.
Oh, okay. Well, it'll still be in the transcript, DB. It'll just won't be usable usable on appeal.
Geofence says it seems like Nick is always being coddled by a judge somewhere.
Oh, you think that's just Nick? Because that's every fucking prosecutor ever, basically.
Don't you think he gets a little extra coddling? Oh, jeez. Okay, sorry. I just wanted to... Anyway. You're up, Diener.
I am? I thought... okay, the court. Mr.
No, I interrupted you.
Mr. McClelland, this issue was raised to the court's attention during the in-chambers matters addressed previously. Mr. Manahan was present, and he heard those statements. And the court's fine with making the record now that the state brought to the court's attention that there is potentially 2 prospective jurors that may be disqualified. Mr. Manahan, having been privy to that discussion, will there be an objection first? And then, if so, then can we make an appropriate record? If there's no objection, then we can just note they are disqualified.
Judge, there's no objection. Kansas Rodenbarger has, I think, pending charges. I represent him on both the pending charges and ongoing child support cases, Judge. So I think because there's pending charges, I think it's appropriate that he be dismissed. With respect to the other individual, I rely on the state to tell me that, in fact, he believes he's still associated with the Sheriff's Department. And based upon that, I think he indicated that individual's last name was Trent.
Yes, Trent.
Should also be removed as well, Judge. Released from the court's order.
Thank you. The court will instruct the bailiff to discharge those 2 prospective jurors as being disqualified under the jury rules, narrowing the prospective jury by 2 people. However, we had in this we had an outstanding turnout. Only 1 person no-showed. That was expected to be here. So we've gotten through all the unpredictable elements of COVID-19 delays and weather delays. Now we're going into the man-made delays. Miss Dean, unfortunately, and hopefully we can get those resolved yet today, so there is a matter that can proceed further. Be at recess until 1 p.m. at the latest, outside of the presence of the jurors, maybe earlier, as may be required. Will be recessed. Thank you.
Thank you, Judge. Thank you so much.
You're welcome,
Judge. Thank you.
Yep.
All my thanks. Thank you, Judge. I'll talk to you in a minute.
I'll see you at the lodge later. Oh yeah. Okay.
Hey, I think Diener interrupted me here. I didn't even finish my thought. That's a hyphen.
Oh, would you have Royal We come up here and start talking trash about me? Okay, I'm sorry. I'm gonna comport myself.
Comport myself. I like that. I like that use of comport. Okay. So that was weird. So I imagine now, let's see, recess at 10:05.
Oh, the guy with the sleep study, or is he going to trial? Is he?
Oh, did he get?
Was he also the guy with the record, the upcoming hearing, or the deputy?
No, I think those two were gone before all that.
Okay, that's nice.
We don't even know of them yet. We're out
But
of.
they missed out on the whole snowman stuff.
Did they?
Yeah, I feel bad.
Oh God.
Yeah, I agree with Sinbad. Nick initiated the discharge of a prosecution-friendly witness. That seems fair.
Yeah, he didn't even like.
Meaning Trent, right? Yeah, I agree with that.
He was just like, "Hey, check this out, guys. This is what I think."
Yeah, and then Manahan was like, "Well, I represent this guy, so hey, Black Swan. All right." We're gonna see how he handles these here amended charges an hour before the trial, right?
Yeah. After playing outside for a little bit, recess.
I'm
one of my favorite cartoons.
So hard.
Yeah, amend it, Fiend. Get in there. Oh, sorry. Go ahead, DB.
I was just gonna ask everybody, what is your favorite recess character from the Disney Channel cartoon Recess?
Literally never heard of it.
Okay, well, that's what happens when you grow up in Croatia, I guess. Fucking robot. Okay, the court. This is everybody. While I'm reading, go ahead and put your favorite recess character in the chat. Google it if you have to. You'll know what I'm talking about. Caption: The state of Indiana versus Jennifer L. Dean, excuse me. Miss Dean appears as before in person by counsel Jeff Monahan, and the state of Indiana appears as before by prosecuting attorney Nicholas McClelland. We are outside of the presence of the prospective jurors. It is 1:07 p.m. We have had a brief recess, and we are now, as stated, outside of the presence of jurors. Okay, I can't get fact checked by All Eyes while I'm trying to read the judge's part.
Then get your facts right.
Well,
yeah, so easy way to.
I never thought out of everybody All Eyes would come for me like that.
I love it.
Mr. McClelland, the state requested a recess prior to now, and we're now back from recess. The floor is yours. Did you win in kickball?
I did. They call me the boss. Judge, the state requested a recess to... The court indicated the state may need to amend its count 2, and the state has done that. I have drafted an amended count 2, and the state would make the motion to amend count 2 at this time, Judge.
The court has received here in open court a paper copy of the amended count 2, and the service of the paper document has been perfected on counsel for the defendant just before coming onto the record within the last, I will say, few minutes. Mr. Manahan, having just received this motion, would you like to respond to the motion at this time?
Yes, Judge, I would.
You may.
Judge, again, at this point in time, we'd object to the amendment. The objection would be based upon Indiana Code 35-34-1-5, which is the statute about the amendment of charges. Most importantly,
I'm sorry. Can you state again slower? I was.
Yes, Judge. I'm sorry. 35-34-1-5.
Thank you.
You ready, Judge?
Almost 3, 5, 3, 4, 1, 5. You may proceed.
Judge, under subparagraph B, it says, the indictment or the information may be amended in matters of substance, and the names and material witnesses may be added by the prosecuting attorney upon giving witness written notice to the defendant at any time up to, and it sets forth the 3 parameters: 30 days if it's a charge with a felony, 15 days if it's charged with 1 or more misdemeanors before the omnibus date or before the commencement of trial. That's subsection 2 if the amendment does not prejudice the substantial rights of the defendant when the information or indictment is amended. So, the argument is, Judge, that by the amendment that is shown here, it necessarily prejudices the substantial rights of the defendant in this case. There are several cases that are insightful on that. First, I'd cite to the court is Abner v. State. In that, it was under the predecessor statute, which was 35-3-1-15E, that said again, following the law and the statute notwithstanding any other provision in this section or the indictment or information shall not be amended in any respect, which changes the theory of the prosecution as originally stated. That would be the filing of the information. That is what is originally stated. The court has gone on to say that the court has strictly applied this subsection, allowing the court no discretion and requiring no showing of prejudice to the defendant in these amendments where it's altered the theory of the prosecution. So, the theory of the prosecution has in fact changed, Judge. It was one in which under the first filing, the acts alleged to have been committed were alleged to have been committed solely exclusively by Miss Dean. Now, what has been charged is an amended count 2, which adds conspiracy, sets forth an agreement, sets forth an overt act involving 2 other individuals, Cheyenne Brooks Brown and Tyrone Lethbridge. So, Judge, we would ask the court to find that it is a substantial and prejudicial change. In the matter entitled State or Reynolds v. State, notwithstanding any other provision in this section, an indictment shall not be amended in any respect which changes the theory or theories of the prosecution, again as originally stated. An amendment, which changes the charged offense in an information, in this example, this case, from murder to felony murder, does in fact alter the theory of the prosecution. That's basically what we've done here. We've changed that theory from battery resulting in serious injury to now conspiracy. So under the reading of Reynolds, a change of that magnitude is what we've proposed here that would be a substantial prejudice, Judge, and should not be permitted because the time requirements under the statute have not been met. In Hawk v. State, when the court's deciding whether or not there's been an amendment that would change in substance the nature of the charge, the court stated if the defense under the original information would be equally available after the amendment is made, and the accused would be equally applicable to the information in one form or the other, the amendment is one of form, not of substance. The amendment of substance only if it is essential to the making of a valid charge of the crime. And in this case, the defense that was available to the first filing, the stated filing, is different than the defense that would be required now under conspiracy theory. So again, Judge, we would say that this, in fact, is a substantial change, and it is substantial, and it prejudices the defendant's ability to go forward at this time.
Thank you. One question, which of course the court may permit the state to propose, I suppose, an argument to the motion, but some observations regarding the procedural posture of the case and originally filed on July 14, 2021, the information alleges the following. Count 2, conspiracy to commit robbery, resulting in serious bodily injury, a level 2 felony, IC 35, whatever the fuck, and IC 35, whatever the fuck. Acknowledging that the allegations following the preamble may not specifically comply with the statute, would not be adequate notice to the defendant of any, at least the theory that the state's pursuing, albeit without the important parts of the theory, specifically that the other persons or persons to the conspiracy. They said that the whole time it was a conspiracy. They just didn't allege the things below and they weren't applicable. And so I think the defense would have been on notice of the state's theory. And so that does that affect a substantive argument for lack of notice?
Well, a couple things. First of all, I don't know where it was defective. Was it defective in the fact that they added conspiracy in the caption and didn't include it down below? Or that's what they intended and they committed it, what was down below, what was in the body of it. But the statute itself is clear. It says they will set forth in the information both the facts that are going to be alleged. They didn't allege no overt fact and they alleged no agreement, Judge. So duly noted, the court has found that they said some sort of conspiracy, but it doesn't tell us what it is, and it certainly doesn't comply with the statute. Again, if it's a defect, I couldn't tell up front whether it was a defect in that they put conspiracy there or it was a defect in that they didn't include the required language under the statute.
Thank you. I think for an appropriate argument at this juncture regarding this motion, we have had some discussions this morning about, well, specifically defense filed a motion to dismiss, which is denied, I suppose. Although there was some dicta, if you will, regarding the validity of the motion in the long run. In response to the pretrial hearing, the state has now offered a motion to amend count 2, and we've heard argument regarding that. But the final question from the defense counsel, or to the court from the defense counsel, Mr. Manahan, will be presupposing the court favors the state's motion and allows this amendment, given that there are still outside of the presence of the jury and the jeopardy is not yet attached. What relief, if any, is available to the defense?
Judge, I would guess I'd go back to 3534.15 subsection C, in which it references upon the motion of the prosecuting attorney, the court may at any time before, during, and after permit an amendment to the indictment or information with respect to any defect, imperfection, or omission from omission in form which does not prejudice the substantial rights. So, first of all, it's our argument that this amendment does, in fact, prejudice the substantial rights. And so I don't know that that grants the court or the state any waiver under the time requirements of the 30 days or the 15 days. The 30 days and the 15 days are at any time before trial seems to suggest to me that it only applies in cases in which it does not prejudice the substantial rights of the defendant. I presume that our relief would be, and if you read subsection D,
that's where I was.
Which creates the issue for us. It says before an amendment or indictment or information other than an amendment provided in subsection B, the court shall give adequate notice, and upon such, permitting the court shall permit us to request a continuance. But since it doesn't meet that requirement, I don't know that we're in a position where we have to request a continuance. I believe the relief that is requested is if the information is now amended and filed, and it is either dismissed or the state, because they haven't filed it, could in fact, I guess, rely and continue to go forward with the charges originally stated in count 2. My God.
Thank you. Before continuing with the record making, Mr. McClellan, will the state wish to be heard? I think I've gotten the statute figured out. LOL. And that gives me more opportunities to belittle our legislature, but that is my opinion. Would they? Oh, we got a real activist judge over here, I see. But that is my opinion. Would they are trying to do things that attorneys should do, but are woefully untrained or unskilled, sir? And so they've tried to do it with stuff worth various timelines and deadlines. They're not directly related to thus made it inherently confusing as to the things are related or not. But that's just only read this today for probably the first time. Mr. McClellan, does the judge wish to be heard? I mean, sorry, whatever the fuck, dude. The state.
Judge, I was told I was gonna have more lines. Judge, I
wish that was true.
Judge, just a response is that I don't think that this amendment to the charge changes the theory set out by the state. I don't think there's any confusion or question about what the state's theory is to the defense. I think you've got to take the case as a whole, and that includes the count 1, the murder charge.
That's not a thing. Sorry, I can't stand this motherfucker.
Not to mention the several conversations with the defense about evidence, stipulation of certain evidence, and just everything that we've dealt with in this case. I don't think there's any confusion about what the state's theory is, and I don't think the amendment changes that or prejudices the defendant in any way. I think the amendment only clarifies the count, and the subtle amendment is basically listing the co-conspirators and talking about what they did together as co-conspirators. And so I don't think it substantially changes the charge. And it definitely doesn't change the theory of the state's case. And I don't think it should be any surprise to the defense, the theory of the state's case. And so I think the amendment is allowed. The one case I found that talked about these conspiracy type cases is Taylor v. State, 677 NE 2D 556. Amendment of information was not error since it did not change the theory of the case, the identity or offense charged, or cause prejudice to the defendant. The state was allowed to amend the information the first day of the trial because information originally contained mens rea of knowingly for conspiracy charge. And so I think the case is on point with what we've got here, Judge. And so I don't think there's been a substantial change, and I'd ask the court to allow the amendment. If the court doesn't, and I guess the alternative is the state goes forward on the robbery resulting in serious bodily injury the way it's written, and the state can do that as well, Judge.
What the fuck? Weenie.
Judge.
Yeah.
You want me to read it?
No, I'm reading it right now.
Okay.
I'm currently reading it.
Oh, okay.
Read it out loud, DB.
Oh, fuck, you're right. I was reading it in my head, my bad. Sorry, guys. Thank you. This guy's very thankful, very polite guy. We'll get to some interesting legal matters down the road. As a precursor, although technically overruled, the Supreme Court recently cleared up an issue handled by myself where I made a fool of myself, fun of the legislator for attempting to address a matter by adopting federal things but not redefining anything. So it just kept everything as it was and at the beginning because they don't know what they're doing when it comes to legal theories and things. So that's been cleared up recently at the Supreme Court. And maybe 3 years from now, this case may clear some other things up regarding the jury instructions for felony murder. Reading it is clearly. So let's see, what is 3 years from this date? Reading it is clearly not a correct statement of law because it would presuppose that the defendant is, in fact, the person committing the act, which negates the theory of felony murder needing to be present in the first place. Also, felony murder probably shouldn't be called that because it's inherently confusing to most attorneys, let alone lay people. But that would be a far later down the road. Looking at Indiana Code 353415, amendment of charge, the court would rely on the following observations in its upcoming ruling. A, the amendment of the charge is a header put in there by Lexis or Westlaw, not by our legislature. And then this section of Title 35, Article 34, Chapter 1, Section 5, just starts off with the amendment of subparagraph A, nothing before it. And there are subparagraphs B, C, D, and E.
What the fuck is he talking about?
I don't fucking know. Why do I always got to read the fucking idiots, dude?
He's
maybe I'm the idiot. God damn
I thought that I know. I gave you the you want to switch?
Yeah, I want to switch with a rifle. I mean, sorry, my bad. So we've got 5 co-equal paragraphs, each similar but addressing wildly different things in the case. And so my analysis is our legislator tried to set forth timelines in some instances for permissive deadlines or mandatory deadlines, and then always gave the courts outs, if you will, in that the habitual offender notice in subparagraph E, there are some deadlines established, but then those burdens can be rebutted. We've got essentially a scrivener's error allowance. If you look at paragraph C, upon motion, the prosecuting attorney, the court may at any time during or after the trial permit an amendment to the indictment or information in respect to any defect, imperfection, or omission in form which does not prejudice the substantial rights of the defendant. Aside from a typo, I don't know of anything that could be amended after trial that would somehow not prejudice a substantial right. So that sometimes is something totally different yet permitted. And I think we're squarely in paragraph D, which has an introductory clause before amendment of any indictment or information other than the amendment provided in subsection D. So subsection B, as in boy, so we're acknowledging we're carved outside of that exception in subsection B now. The court shall give all parties adequate notice, which in this instance was measured in minutes or hours of the intended amendment, which has now been filed upon the state, on the court. Oh my God. Been filed in open court by the state. The parties have been given an opportunity to be heard, and the court is going to permit the amendment, and is so at this juncture the state's motion to amend count 2 as written and submitted in open court to defendant today is granted and amended. Count 2 now provides conspiracy to commit robbery resulting in serious bodily injury, a level 2 felony, Indiana Code 3542, whatever, and Indiana Code 3541. Nicholas McClellan, being first sworn upon his name, on his oath, said between June 15th, June 21st, and June 20 in the county of Carroll, Snippet in the Indiana Estates, Jennifer L. Dean did, with the intent to commit a felony, agree with Tyrone Leftwich and Cheyenne Brooks Brown to commit the crime of robbery resulting in serious bodily injury, with is knowingly or intentionally take U.S. currency from Willie Smith Jr. or in the presence of Willie Smith Jr. by using force or by threatening the use of force by Tyrone Leftwich and or Cheyenne Brooks Brown to commit an overt act in the furtherance of agreement by hitting Willie Smith Jr. in the head with a baseball bat, all of which is contrary to the form of statutes in Indiana 3542 and Indiana 3541, and against the peace and dignity of the state of Indiana. And that amendment is granted over the objection of defense counsel. Ms. Dean, as you're here with counsel, a plea of not guilty will be admitted or entered for your benefit at this time to amended count 2. Mr. Manahan, as we are still here, day 1 of the scheduled trial, now that there's been this action by the court, are there any requests from the defense?
Judge, there are no requests for continuance. My client has been waiting dutifully for a long period of time. 3 continuances, one of which was under a speedy trial right. Now in the position where the court has found that the amendment does not prejudice her rights at this point in time, electing to continue this further would only continue to harm her of sitting in jail, Judge. So we're prepared to go forward.
Thank you. And though discussions occurred off the record to essentially determine where we were procedurally, I think the anticipation from all the parties prior to this issue was hopefully select a competent jury today and then proceed with the evidence tomorrow. And I suppose a theory of the case alteration certainly affects the examination for competent jurors. Hopefully the permitted amendments aren't so foreign that the examination can occur yet today. Mr. McClellan, I know, it's the whole caps lock thing. Mr. McClellan, any pretrial motions or requests before we take the next steps in the scheduled trial by jury?
No, Judge. The state's prepared to go forward. I would ask the court for a short 5-minute recess to make some arrangements for other things outside of court. But other than that, the state's prepared to go forward with the voir dire, Judge.
The court, a man, Mr. Benjamin Diener, and any further pretrial. Sinbad, are you saying I sound like a girl, dude? Any further pretrial motions or requests before we take a brief break, which will be then anticipated by the court to be followed by bringing in the prospective jurors. The court reading its 8-page document, which is essentially sets forth the procedures and expectations and transitions directly into voir dire, which then goes directly into examinations, which as the court does not limit that, will take breaks as requested or as necessary, but will likely go all afternoon. So any motions before we take a break, Mr. Manahan?
No, Judge.
No. All right. We'll be at recess. Try to keep it as brief as possible. Get the fuck back here. And we'll resume as soon as the parties are able to. Thank you.
That was weird.
I'm just doing my best here.
You're doing great, Fiend. He didn't even address. So, what do you think? I'm not going to say what I think because I'm not a lawyer. I don't know what I'm talking. I don't know anything about.
You're a paralegal.
I don't know shit about.
Yeah, you're definitely the closest to a lawyer.
I don't know shit about fuck, so I'm not going to say anything. But that felt very odd. No? Doesn't that whole thing feel very odd and like not legally sound?
Well, yeah. I mean, I think the Benji was trying to guide them, but Nick wasn't really picking it up very well. And so they're kind of just stuck with.
I think Manahan
he's trying to give the state what the state wants, but like the state's just wrong, and he's trying to help the state, and the state's like, well, I don't understand how to do that, and we're like, well, like there's only so much help you can give somebody without it getting like really, really weird.
I just feel like I feel like Manahan made a really good argument as to why it was outrageous for Nick to try and amend his entire case right before the trial was supposed to start.
Well, I cited a case where it had happened, something kind of similar. I mean, maybe I don't know. It was close. I didn't read the whole case, but it had those words in it. So
yeah,
I'm going with it.
Yeah.
The state just needs to get what the state wants. Come on, guys. Go along with it. I don't understand why the defense isn't going along with the state. Caused me a lot of problems, Manahan. But what if I give you a basketball? That smooth everything over?
A basketball. What if I induct you into the Basketball Hall of Fame?
Well, that depends. Is the basketball signed by a bunch of high schoolers? I don't know.
Obviously, it's a Delphi high school basketball.
It'll be signed by all your friends. The high schoolers just played with the ball.
Oh, so it's a high school game ball.
Yes.
Well, I do have some breaking news, guys. I was able to obtain a clip of Nicholas McClelland right outside of the courthouse directly after this during recess.
Well, see, my old man is dropping by the school, and I was thinking, if you're not busy, that maybe you guys would get a kick out of pretending to be my best friends.
Wow.
That was beautiful.
Nicky's random weenies, dude.
Sinbad said it is outrageous, but Indiana law says it's okay. That seems to be the theme of all things. It's outrageous, but Indiana law says it's okay.
Well, the legislator.
Oh, what was he saying? Hold on. Pause. I wanted to go back because this man has beef with like so many people. He has beef with the appellate court. Remember when he was like, "We only have one newspaper in this town, so that the appellate court knows."
This fucking legislator. I mean, legislature.
He was like,
they suck.
He's like, and another thing, and it's like, that's
and these
not
headers,
relevant, Your Honor.
These headers, they're just making them up out of thin air.
No one.
And he's like, he didn't even know if it was a fucking like website to put it in there, or.
Where is it? I think it's here.
Like, was he talking about the universal citation from the top of the?
He's literally talking about nothing. Look at he's literally.
No, yeah, that is what he's talking about. I think
the universal citation.
Well, yeah, it's just like the website.
Where's he say? Hold on, here he comes. This is it. This is the best. Thank you. We'll get to some interesting legal matters down the road. As a precursor, although technically overruled.
Yeah, he's like, oh my fucking god.
The Supreme Court recently cleared up an issue handled by myself where I made fun of the legislature.
You be saying too much, bro. The court of Indiana already said that.
Why are you making fun of the legislator? They don't know what they're doing when it comes to
the Indiana legislature does actually for sure suck really badly. So he's not wrong.
Yeah, but I guarantee you he doesn't think that they suck for the reason you think they suck, bro.
He doesn't know. Yeah, he don't know shit.
There's some overlap. I guarantee it.
Is there overlap?
Yeah, there's overlap because they suck. I mean, they legitimately suck. They're just not effective and they don't do anything. There's a reason everything's fucked up in Indiana. And it's 100% the legislature.
Can you imagine? No, I believe that. Like, he said in 1,000 words what he could have said in 10.
Yeah, he didn't. I don't know if he's trying to like. I mean, he did have to seem to have some like foresight that like, hey, what's going to happen with this case in 3 years? So,
nothing good.
Yeah, I think he kind of knew, and I think that he was trying to like just make some statements for the record.
It's pretty bad. Pretty bad.
Dude, I was in college when this fucking.
If you guys in chat don't appreciate recess right now,
I've never seen this cartoon. Never seen any picture from this cartoon. Never seen any clips. Nothing.
Surely that can't be the case.
Yeah, it is the case, dude. I was at frat parties when this came out.
Frat parties, okay.
who you have frat parties with?
Anthony Rene Grino.
Well, I wasn't in a frat, but I mean, so. Are you fucking insane, dude? Oh boy.
Anyways, recess was awesome. Thank you, Jenny. I appreciate you. I was in college when I was in high school. Wow, and you're.
I was also in college when I was in high school.
Miku's been in college for 13 years. Wow, that is impressive. Play the rest of the fucking insane tape, please. Yeah.
This is the whole fucking shit. You don't know fucking anything. You're a fucking idiot, dude.
Oh, that was fucking funny, bro. Oh, you need to DM me if you object to me playing this.
What?
That's all I got, guys. I can hardly fucking read. I just got little short clips of zzz, wham, wham, wham. I got sound effects and memes. That's it. That's all I got.
Keep at it. You're doing
good. Here's another one.
What?
That's what at 50% volume. This is what at 100% volume.
What?
They're different volumes. Here's a clip of Brian Harshman.
State. Hi, my name's Brian Harshman with the Indiana State Police in the Indianapolis District. We're out at the 1998 State Fair this evening, and we're going to talk about a few things that we do at the State Fair. Tonight, what we're going to be doing is working the Midway, and we're going to be doing some things on the Midway. One of the big things we do on the Midway is we handle a lot of lost children, find a lot of lost parents, too.
Where's the parents going, buddy?
A lot of lost children.
It's in Indiana, dude.
It's too many. Stop losing the children.
He aged.
Dude, he aged. That's
Yeah,
what you said, but I was trying to put more emphasis on that. Sorry, that's
you
all
did good. No, I think that
Okay,
the emphasis was needed. It was necessary.
Thank you.
He's
Hey, you guys ever seen a picture of that guy? He's fucking older now.
Amazing.
Yep, here he is. I'm going to show you guys a picture of him. He looks a little different. Here he is.
Looks great. Oh my god.
Oh, Miss Cloud. There he. No, that's not him. Handsome guy though, you know. Mm-hmm. Mm-hmm. Okay, I got another little clip for you guys here. Was that a Vinlander? Dude, it was a fucking British Vinlander. They got British guys in the Vinlanders.
Well,
hey,
dude,
hey, bro.
Old English was written in runes. I just like that.
Hey, bro, you like Odin? Bro. Hey, bro. Here's the IT guy for Carroll County. You guys know him.
Geek Squad, eh?
Yep. He's really good with computers.
This is true. He's good at retrieving lost things. Lost children, lost data.
unspent rounds.
It's just
it's
just the buttons. The buttons with the blue lights. Those cause some problems.
Oh jeez.
Yep.
I miss him.
I do have a picture of. You guys wanted to see what I look like?
Oh boy.
Here's me real quick.
Wow.
Yep.
Did you ever find your Amy?
The amazing Amy? No, I didn't. She came back, but it wasn't her. It wasn't the same.
Yeah. So do we think we're gonna have a trial in 3 weeks?
Let's get. If you can go first, what do you think?
You're not blocked, Jason. I can see you. Oh, I see you. I'm watching you.
I think you can just see it because you're an administrator.
No, I wouldn't be able to see it.
Oh.
Who would block him? Maybe I did block him. Am I the only one that can see these?
We going to trial, you think, or?
Sure, why not?
Well, I don't know, because of someone's rights maybe in jeopardy.
Oh, well, you know what? I did think that initially that they were gonna move to continue, but I think that she's really telegraphed that she will deny that. So I don't know that they will actually request it. Also, I don't know.
Request what?
Just a motion to continue.
You think they're gonna?
I thought that they would ask for it, but I think that they may not now because they know she's going to say no.
Yeah.
But what if they go on appeal and they say that her ruling allowing them what?
No, go ahead.
You go ahead.
No, go ahead.
Okay, well, I was going to say that
I was active listening.
Oh, well, I have headphones on, so when you talk, I can
Okay, sorry.
Okay. So I think that, if they do appeal this eventually and they don't file a continuance, I could see them saying, I could see the Supreme Court or the appeals court saying that they believe that they should have objected or they should have filed for continuance if they thought, well, it doesn't really make sense. It's that much, but keep preserving the record. If they file for a continuance, that may preserve the record that they did not have adequate time to prepare because of the judge gutting the third party defense,
right?
While letting them prepare for so long.
Well, I don't know. I think this has been something that's been floated for a long time, as far as they're not stupid. That they may have anticipated this outcome all along and have that their backup plan may not even be actually their backup plan. It might be their primary plan. They just want to.
You're a legal loser.
They just
You're a legal loser. That's what you are.
Preserve their first defense by
legally, you're a loser.
Sorry, go ahead, dude.
I mean, I don't know. It's speculative, but if you were gonna be smart about it, is this something somebody might do where you show your second, you show your backup plan the whole time as though it's your first plan, and then they throw out your backup plan, but you've got your first plan lined up all along. So
yeah,
I mean, there's endless things that you could actually go with as a primary theory here.
Yeah,
I don't know. I mean, just saying, if you're gonna floating a bad theory and incriminating people falsely, there is a lot pointing in that direction, and it was investigated. So on to a very strong amount, it was substantiated, is legitimate, but also the people that they were thrown under the bus here are total shitbags. So if you're gonna do that, you probably feel least bad about doing it to people like this, because fuck those guys.
Fuck them. But also, the state didn't do them any favors by not investing. They could have easily cleared it up, you know?
Yeah, no, that's the entire point. Like, a lot of people are like, oh, you're buying the onus theory. Like, you think the onus did it. And like, no, that's not even the point at all. The entire point isn't that the onus did it, is that the onus should have been investigated more thoroughly. Duh. Like, they obviously should have been. That's the entire point. It's not that they did it, just that they warranted further investigation.
Yeah. I agree.
Which, like, yeah, you can have any theory of the case and still just agree with that instead of being a dick about it. Like, they obviously should have been investigated more thoroughly.
So, so you think that the strategy will be to attack the investigation?
Well, I've always thought that's going to be the primary, like, pillar of the defense. I mean, it's just, like, your baseline. I wouldn't be surprised if they have an actual theory of the case, which I think is like, I think presenting a theory of the case is going to be strong in court if the state is really lax on providing a theory of the case, because like, if you got two competing narratives, what's an actual narrative versus no narrative at all? Like, it's easier to pick the actual narrative that like actually makes like cohesive sense.
Yeah.
So I wouldn't be surprised if they say somebody else, and they may very well have a lot more evidence that points to somebody else. I mean, the one of the big things is, you know, those you know, the geofencing is out, but geofencing isn't pings, and you know, they've got these pings of 3 third-party suspects, but they very clearly weren't saying it was any 3 specific people that they've talked about a lot. So who are those people? Like, is that really more their direction? Because that's a lot more of a nexus where you're actually placing somebody right there at the right times. And I mean, you know, that seemed to be the part that was missing with some of the Odinist type stuff, is that you couldn't place them exactly there, which is like, if you could, then that would just be the crime solved. Like, obviously those are the people that did it, and just arrest them and like, case closed. But like, you know, you don't always have all the proof, especially when you don't investigate things.
Yeah, they didn't do shit. Is looking at the shape of your head here.
Yeah, that's disturbing.
Yeah, it can't be good.
Oops, one sec. Oh god. Okay, so we have a question in the chat here. It's a damn fine question. What
Read
is
it.
the first plan? What? Excuse me?
Read.
Go
Read
no,
it.
go ahead.
Read it.
Read it.
Read it.
Read it.
Read it.
Read it? Read it? Okay. The question here from fellow cartoon character. What? Oh,
I'm so sorry.
I was gonna read that.
Sorry.
Okay. What is the first plan that doesn't include Ron Logan or Keegan Klein?
Well,
A lot of people. Oh, go ahead.
I don't want to answer that question, but it could still include a lot of people. Yeah, you could go Garrett Kurtz, you could go James Chadwell, you could go, I don't know, whoever's phones those are, like whoever they are, you can go with those people.
Ooh, Confession Week. Is that like Shark Week for non-incriminating statements?
Mm-hmm. Yeah.
I mean, I don't know, man. I think
we know.
Like, the state does not have a good game plan. Like, I don't think that that's gonna play super well. Like, where you just like if you do a whole week of that stuff, I think you're gonna lose the jury on this is dumb. Like, it's gonna be repetitive and like, I don't know. Like, if they got like some good ones, just use the good ones and do your thing. Like, I don't know. The jury's going to notice if you don't have any real evidence. Like, they're definitely going to notice. Like, they're not going to pull the wool over their eyes and be like, oh, man, okay, are we going to get to the fingerprints and the DNA? No? Okay, like, I don't know. Like, fibers? Like, I mean, anything? Bueller? Like,
Who's
where
Bueller? Another suspect?
Yeah.
That he's not allowed at the trial. Would they let Garrett Kirk's theory at the trial? Like, I don't know how effective it would be either way, but do you think if they start talking about him, they'll file like a motion
I mean, I think
right then and there?
I think generally the same third party like nexus like requirement stuff is going to apply, but I don't know. I mean, it's funny that like, you know, the state preemptively included people in the motion to eliminate that the defense never mentioned. Like, I don't believe the defense ever mentioned Keegan Klein or Tony Klein or Ron Logan, like, ever.
Right, at least not in like public.
Not in public filings, yeah.
Mm-hmm.
But sure enough, their names was like, man, I don't know, like, I don't know if the state just wasn't thorough enough to like, dude, your list should have been a lot longer because there's a whole bunch more people you could include, a whole bunch.
How we feel about Ron Logan and his involvement? I feel like there's a YouTube channel I used to watch a lot of. I just watched something the other day that they posted is a little bit different than their. You know what? Never mind. So Garrett Kurtz, do you think, if they have other people there and it's not specifically mentioned as not being allowed to be mentioned in the motion to eliminate, are they going to try to exclude it? Because if you're Nick, like, I feel like if somebody is just whatever's left after that, if it's a theory that they're gonna try, you kind of probably just want them to try it because it's so.
Even if, and you just, I mean, if you just think about like, you know, just pre-arrest and the state of social media, Reddit, and mostly, you know, people talking about the case, like, you know, the Odinist stuff wasn't a leading theory at all. You know, there's several strong theories of people that were involved, like, and a number of them, like, so I think, and there's, you know, those were substantiated like to a fair amount. Obviously, like, the problem is that like I mean, this is the problem. Like, all these theories were like probably pretty good, and law enforcement probably didn't actually dig down and investigate anybody very thoroughly.
Yeah, that's true. I just want to know why.
I mean, it does beg the question why, and because it does seem like it seems purposeful that they intentionally pull up short.
Although I do believe they genuinely thought that oh my god, we finally get to see what that is. Uncanny.
It really is, isn't it?
Yeah,
thank you.
Actually, it is. I feel like the investigation genuinely believed in their Klein angle. I don't think it was like, I don't think it was posturing. I don't think it was like just trying to close a case. I really think that they believed that that was the conduit to something.
I mean, even if you got that theory, like, do they believe in themselves enough? Because, like, you know, they did that river search, and they're like, well, we were looking for a phone and a knife, and we pulled a bunch of phones and knives from the water. Like, okay, like, are you sure none of those are the right ones? Like, how sure are you? Like, you're not very good at doing things, so are you sure that you didn't, like, it's not one of those? How sure are you?
Well, and then, well, they had to, so they talk about all the phones they got from the river, all the weapons they got from the river. Like, how much analysis did they have to do then with everything that they, like, the fruits of that search? Like, did they have to then, like, actually go and...
Keegan told them it was a red phone, and they only found a pink phone. So, I don't know. Does phone color fade over years in water? I don't know. Like, we'd have to...
You think they went in each device
they
and
didn't have Chat GPT to ask these questions, so, like, you know, it's understandable that
they don't have Luke
they just can't figure anything out.
I'm just wondering how much investigation, how much, like, many resources. I don't even just mean like monetarily. I just mean like then once they got the...
Well, I mean, that's kind of the point.
Weapons,
I'm expecting that they almost did none. They just did a visual, like, look at everything and be like, I don't think it's here. I don't think it's one of these things. Be like, well, no, you would have to you'd have to extract all those phones or something. Like,
right,
I don't know.
you have to figure
or if you can't extract the phone because it's damaged from being on the water, that doesn't rule out that that's not the phone that you're looking for. It still could be the phone. I mean,
you'd be amazed what you can get off a phone that's been submerged in water.
Yeah, whenever I find phones submerged in water, underwater snorkeling, when I'm welding,
underwater snorkeling.
well, you get, well, I mean, clandestine extraterrestrial snorkeling.
Yeah.
Okay, so anyways,
I lost a phone in a creek one time. You think everything's on it?
Dude, is anyway so new punctuation in the English language? Anyways, so I'm gonna bring up a comment I seen back a little while ago. Another cartoon character fella said, Jessica, that ship has sailed. Talking about the confessions. The confessions are in.
Yeah,
the defense. That's what I'm saying. And the defense didn't dispute Harshman's description. So is this the only time they can dispute these, or can they dispute the description at trial during cross-examination while he's describing them, or are they going to have them entered into the record and they're going to read all 61 of them?
They're going to do a confession week.
Well, yeah, I did hear about confession week. That does actually sound interesting.
Fun.
I mean, I hope that they don't, for even their sake. I mean, I'm not I don't know. I think it's going to be bad if the state puts on just a horrible case. I mean, it'll be funny, but they probably shouldn't. I don't think reading out 61 confessions I mean, we know that they're not 61 confessions. They're going to be 61 random statements that they're going
to play them,
weaving into a tapestry of you guys think these are confessions, right? We're telling you that they're confessions. The words aren't obviously, if you just read the words, they don't sound like confessions, but we're telling you that they're confessions.
Well, so what is the line for calling something a confession? I mean, I guess in the space, online, we have probably a different definition than the legal. Each state probably has their own legal standard on what's considered a confession, which actually I don't even know if that's true at all, because
do they even use that word in any
true either? I'm gonna chat GPT that question.
Yeah, chat GPT that shit real quick. I was actually gonna Gemini AI it, but yeah, go ahead, chat GPT. So it seems like if the state is up there calling something a confession, and my theory is that they're just gonna try to say that word as many times as possible and not actually talk or cite any specific confessions. And I think that it's so prejudicial to say that there's a confession, that even talking about it more would kind of make the defense worried about the impression it gives on the jury. So the more you even go and start arguing about the specifics of a confession and how much it's actually probative or reliable based on the evidence that only a killer would know, I think that really is just going to muddy the waters for the jury, and they're just going to be hearing the talk and deciding whether or not a confession is reliable or not. And I think talking about that alone is enough to really get them to say, well, he did confess, but how reliable is it? Well, then you've already moved the bar on these statements to a confession.
Right. So here's the chat GPT answer. So most of the things, most of the requirements or the elements are things that have kind of been litigated already. It's voluntary, you're aware of your rights, and it's admissible. So those things are knocked out already. So the fourth part of it is specificity. So the confession generally must contain specific details that correlate to the crime in question, making it credible. And I think that's the part that it's not going to be as great as they're trying to make it out to be.
They're going to play them. They're going to see them on a video and they're going to hear them on audio, and it's going to be very
but is it going to be specific to or specific and relevant to the crime?
No, of course not.
Exactly. That's so that if it's just random ramblings, it's not going to be. all that useful.
I don't know that they wanted all of them in, but I'm glad that they are all in, if any of them are going to be in.
Right, because I mean, the defense will be like, I mean, I would think that the state will still pick and choose and try to like narrow it down quite a lot, because I think it's just a really bad strategy to lay them all out.
I think it's insane.
But the problem is the defense is also going to be like, well, you also potentially wanted to include these ones, and so we're going to include these ones because you can see like how like the types of statements being made, like these are just a couple in hundreds or thousands of statements that are made that like are not very relevant to anything.
Yeah, I know. It's stupid. I think that I personally,
I mean, I would have to hear them to really weigh how much
motherfucker, dude.
You'd have to hear them to weigh what, Fiend?
I'd have to hear my own voice to fucking think over here.
I mean, I would weigh its statements or confessions like to a certain degree, but it's going to depend wholly on what they include.
Right.
And I don't think it takes you like all the way. Like
this isn't true. I agree with this statement. Oh wait, they didn't dispute his description. There were 60 detailed confessions, right? But they did say that the confessions in no way matched the facts of the case. I mean, sure, they were detailed, but they were wrong. They were incorrect details. What detail did Harshman provide? Let's talk about Harshman. Tell me one specific detail that Harshman got.
He said, I'm sorry, he said that he did it.
Right.
He said he didn't have his notes in front of him.
Oh, he didn't have his notes at the evidentiary fucking suppression hearing.
Was I supposed to bring those?
It's clown college. This is so stupid. How do you not have your notes at an evidentiary fucking hearing? Nobody had their fucking notes. Nobody from the state had their fucking notes. That's convenient.
Well,
I remember.
I mean, everything is like narrow, like in these hearings. So, like, you know, your goal is to get the motion eliminated granted in full, and they did. So, like, you don't want to bring in more information than you have to. If you can avoid it any way, shape, or form, if it doesn't help your current goal of just winning this, then don't do it.
Yeah.
May I read a portion of the transcripts?
I beg you to read of anything. Go ahead.
You're so good at reading transcripts, DP.
Yeah, you are. Please read it.
Christ.
Read it slowly, though.
Here I go.
Thank you.
Question. So if in reviewing this volume of information from a perspective, this is, by the way, this is cross-examination of Brian Harshman by defense counsel at one of the hearings. So if in reviewing this volume of information from a perspective of phone calls and videos and suicide companion sheets, did you observe any external factors that introduced themselves in April that coincided with Mr. Allen starting to confess? One of the things that I was able to know, and you know, you got kind of keep in mind to date, I'm somewhere between 650 and 700 or 670 total phone calls made by Richard Allen. Well, he's been detained. Breaking that down into hours, we're somewhere between 150 to 170 hours in just phone calls, not including any video or anything else that I've watched. So the volume of calls is immense. So I've been able to, I feel I've been able to at least been able to pattern his conversations and what's going on in his world just by the simple fact of the amount of time I spent listening to his conversations. And one of the things I noticed was that in March, early in March, Mr. Allen became an individual that was involved in reading the Bible, and as such, he proclaimed numerous times that on March 21st in 2023, he found our personal Lord and Savior Jesus Christ and found God. Some of those
found God.
God. I'm more of a POD kind of person.
That's great for him. I know you.
Some of those that yeah, whatever. God is my favorite 3-letter agency, but it's just like him kind of, there's a lot of hyphens in here. I'll say that in this transcript. There's a lot of what is it called? An end stop?
Mm-hmm.
Yeah, there's a lot of end stops in here. He doesn't go any further than that. He
didn't finish a thought.
And the sins that he committed. Question. Okay, but nothing specific about a particular sin when he's talking about that. Yeah, but does he talk about the crimes he's charged with in the case? Yes. Oh, yes. Okay, well, what does he talk about then specifically? Yes. But when he has confessed and he's talked about these crimes very specifically. Okay, and our question, are we talking about one time or multiple times? Answer. It's I've tried to put it, I tried to find a way, guys. I'm literally reading this verbatim. I tried to find a way to put in a numerical sense, because there are varying degrees of, what I believe is, there's some confessions where it's just like, I did this, and this. And what though? Like, is this
right?
Is this exactly what he's talking about? He said, I did this, and this.
This. Define this.
That's a great question, sir. Define did and this in these commas here. Okay, and
the crime as alleged,
as charged.
Honey, I committed the. What was it? Honey, I committed the.
See, that by itself is very problematic, because you got accomplice liability is charged, which is like very, very wide range of possibilities.
Well, they said that in a couple of the filings too, that he, in the early filings, he admitted to the crimes as charged. And that is the one thing that really perked me up about the confessions, like last year.
Because before the Supreme Court hearing, murder wasn't charged; it was felony.
Right, and it was kidnapping.
So as charged wasn't the killer.
Right, and then later they talked about bringing like the actual charges, and then they referred to him basically as a bridge guy, and like the killer. The murder.
There was one filing where they finally came out and said he's bridge guy.
Sinbad Sailor says, you never bring your notes to the witness stand unless you want them to be immediately handed over to opposing counsel. Yeah, but
you need to be able to answer the questions that are asked of you. You can bring a business record, a document that's a business record. It's a hearsay exception. You can literally do that. You should do that. Walla had her notes. In fact, I bet that. Well, I don't know.
Okay, so
I'm pretty sure the defense has most of the notes.
Somehow. Go,
okay. DB. So you're saying that they don't bring their notes because you don't want it to get turned over. Let's just say that is his motivation, and that's exactly what he did. Do you think he forgot what was in all of the confession, all 61 of the confessions?
Right. There's one detail.
He spent what he categorized, what he talks about being hundreds of hours listening to him. And you would think this is probably one of the most important cases he's been involved in his career, and he has been an investigator for a long time, and he's a trooper for a very long time. So I would suspect that he has a general idea of what he has heard. And when he's talking about, they say, were you talking about one time or multiple times? And he says, it's I tried to put it to find a way, but in a numerical sense, because there's varying degrees of what I believe is, so he was going to say, what is a confession? And then he stopped himself and he said, there's some confessions where it's just, I did this, and there are some where you sort of dance around the outside of it. Well, if you're dancing around the outside of an incriminating statement, is that a confession? I don't know. That's me, not Karshman there, but
right.
But this is a direct confession that I've been able to find. But just direct confessions that I've been able to find telephone calls, the videos.
Yeah, I need more information.
So how do you hear a confession
on a video with allegedly no audio?
With allegedly no audio. The door sheets are
sign language.
Huh?
Sign language.
He was signing.
I thought it was a riddle.
Oh, so that's why they gave him a new tablet, is because he was doing ADA certified sign language with people he was confessing to. It must be.
Could be.
Okay. Well, the door sheets. I'm 60 plus confessions at this point, and that's a conservative number without a doubt. So conservative. So meaning
does he have like
an abacus? No.
That's what she was gonna say. I'm pretty sure.
I thought so too. I'm 60 plus confessions at this point, and that's a conservative number. I'm being conservative. And then the next question is, okay, and the ones that are more specific, does Mr. Allen include details that only the person involved in the crime would potentially know? And I'm guessing that the attorneys knew the answer to this question.
Yeah, I think they probably did know.
Well, that's rule number 1, DB. You never ask a question unless you already know the answer to it.
Is it really?
Unless you're Nick McClelland.
Yeah, no, I've listened to like lawyers on YouTube.
I thought rule number 1 was if your public defender shows up with Velcro shoes, you're gonna want to take the plea deal.
No, dude, no. I would 100% trust somebody with Velcro shoes.
Okay, but are they a bald guy with a ponytail?
Even better.
Okay.
I can tell.
I like your style.
This guy's definitely gonna rock it because he does not care about fashion. He cares about the law.
Was he wearing Velcro shoes?
You what? That's not ableist. Don't even try to rope me into some like I was trying to make an ableist argument.
Who was doing that?
My other personality. Okay, and the ones that are more specific, does Mr. Allen include details that only a person involved in the crime would potentially know? He says, I believe that is correct. Yes. Now, never a truer word would say. He says, I believe that is correct. Yes. The follow-up, comma, yes, means he's trying to support a statement with another affirmative, which means he's being untruthful. And does he?
DB's coming around to the statement aloud.
No, actually, I just made that up. You can just make it up.
It sounded very convincing.
And question, does he ever talk about an obligation as a Christian to be honest and make things right? Answer, I don't recall that exact phrasing. So I'd be hesitant to say, but I'm not sure. Okay, well, does he, how does he confess to his family receive these calls? Generally, the first confession were obviously, Mrs. Allen and the mom were extremely upset. Rightfully so. I mean, it's difficult to listen to, he's just conversation with them about it because, that's their husband, their son. It's clearly extremely difficult time for them. And the confessions he went on with Janice, Richard's mother, would say, they're messing with you. They're messing with your mind. Kathy would kind of reiterate the same thing. And oftentimes Kathy would tell him to stop talking. There were at least once, where she said, Mr. Allen was talking and she said, stop talking. It's something along the lines of, I'm going to just call Brad, his attorney. Does that mean she was like in a conspiracy with Brad?
Yeah, they're beating him. Kathy and Brad were beating the fuck out of him.
I'm just going to paste this shit because it's fucking insufferable. But.
Yeah.
Okay, so do some of them statements actually include motivations for the crime? Answer, yes. And do some of those statements relate to why he would have delayed his confessing? Yes. Okay. Let's see it. Let's hear it. Where's it at?
So this whole found God stuff, this is like one of the things that like I continuously gripe about as far as fucking media not like actually like doing any like research into Richard Allen. Like, is this even plausible? Like was he religious beforehand? Like, finding God typically implies that like he wasn't religious beforehand, but that's not something that we know or don't know. Like, we just don't know. Like, we don't know whether he was or was not religious previously. So
Get
the
his dog
whole
tag.
the whole premise of him finding God, like does that have a leg to stand on or not? Like, I think that, like, absent what he was like beforehand, like,
Okay,
I know his grandparents went to church. I know that.
Sleuth has a statement here. He says he needs God to be with his family. If he was innocent, why would he need God now?
Because he's having religious delusions because he's psychotic. Any questions on that? These are religious delusions.
Well, you also might need God if you're just going through a hard time, like you're fucking imprisoned. Like,
I'm sorry. I find it very hard to believe that after 6 months, all of a sudden he finds God and then he's running into Wall's face first the next day. I think he's having religious delusions, and I think the companions are praying with him outside of his fucking cell, feeding into his religious delusions, because Dr. Walla, the psychologist that was employed by DOC, that trusted her to employ her, literally diagnosed him.
I mean, we're missing a lot of details. Like, are they doing Odin prayers outside the are the companions doing Odin prayers, or are they doing Christian prayers? That's not specified.
I don't fucking know. I just know that
right.
This man
We don't know.
You're not finding God one day. I want to confess, so do it. He can't. He fucking can't.
Okay, well, it can't. So he can't because his defense attorneys won't let him, right?
Yes.
Well, that's not how anything.
They won't let him and his wife.
I read that.
Things just don't work that way.
Oh. Okay, he needs God to be with his family. Okay, so let's say that he confessed because he needs to be with his family. He wants to be with his family. And the only way he can be with his family is by changing the comment. So I can read Catastrophe's comment.
I'm so sorry. I'm so sorry.
I'm just kidding. Okay, so like, what if he didn't do it? Why would he look for religion now? Well, I think, yeah, he's going through a hard time. And, they say you find God in weird places like foxholes and in the Westville Correctional Facility admin cell A9, right?
I've never seen so much ignorance to very obvious mental illness in my life. Other places are watching this case unfold, bewildered and fucking horrified at the level of ignorance and obstinance towards knowledge, credentials, education, like anything, evidence, forget it. Science, no, he wasn't mentally ill. He had depression, and that wasn't anything. Like, that's not a...
I mean, I wouldn't...
What does that have to do with... But what does that have to do with anything? What does that have to do with anything?
I was going to read it.
I think a lot of, like, prisons, this is not, like conduct that's outside.
I'm sorry, I keep doing that.
Oh, no, go ahead, Fiend.
No, go back.
I don't know if I heard it read somewhere else, but Prof read the letter from Bastone about all the shit that happened to him, and like how they beat the crap out of him and broke his foot and like broke his ribs and like.
While I just watched.
Yeah, and like that's not, I think that's probably more the norm than what we would like to believe. Like, I think that and I mean, it doesn't make it okay, but there is a distinct difference between somebody that's convicted of a horrific crime and somebody that is a constitutionally innocent. So but I think that once you're in these places, that's how it goes a lot of the time. Like, you will be beaten, raped, like you will be treated poorly, unfairly. Like, they will not follow the rules. They'll do whatever they want. Like, and there's nothing that you can do about it.
There's not. There's literally nothing you can do about it.
Okay, so I'm gonna go back up to this comment real quick. Mr. Sailor said Harshman indicated his mother and wife were also very religious. Now, this actually tracks really well with this comment too by All Eyes on Delphi. New creator, never heard of her, but I heard she's got good stuff. The way that Harshman spoke for Kathy was so fucking gross. Walla confirmed they were messing with his mind. He was disoriented and his wife was trying to ground him, not cover for him. I think this is an interesting point because if you think that Mr. Harshman just randomly forgot any of the actual incriminating statements that only a killer would know and could not touch on them when he's on the stand, but he remembers the way that Kathy and Janice responded when he did these confessions to him, it's just fucking bizarre. All Eyes also said there are bodies of literature that discuss the data in solitary confinement. How people are saying something that was literally designed to be coercive. Is it coercive? Drives me crazy. So in prison, they call solitary sometimes jail because it's the jail inside of the society that they're in. It is designed to be punishment. And that's why it's a part of a prison system. When people have been found guilty, they could be punished. And usually when people are not found guilty yet, they have to have additional restraints, different additional requirements to be able to hold them in solitary confinement because the majority of solitary confinement done in the United States of America is done post-conviction. And there is also the fact that a lot of people will say there's mental health impacts of being in solitary confinement. And I agree, of course. That's impossible to rule out that he has had some negative effects from just solitary confinement. But also, and then people like to bring in, there's harassment, there's medication, there's all this other stuff. For me, my point I like to make is what he's going through is bad enough. Nothing else needs to happen to him. It's bad enough. Right. His whole life got completely turned upside down. Even if he's guilty, these things could still affect him to where he's saying something that could be incriminating during an episode of psychosis.
Right.
Like, those things are not mutually exclusive.
That's why Brad Rosie has argued again and again the guilt or innocence of our client is fucking irrelevant as it relates to the admissibility of these statements. It doesn't matter if he's guilty or if he's innocent. The statements were obtained while he was in distress, psychotic.
Well, whether he's guilty or not is so irrelevant because he's fucking innocent right now.
Right. But I mean, even if like, and I just find it really hard to believe that they can involuntarily medicate a person with an antipsychotic as strong as Haldol and then deem anything that comes out of that person's mouth to be like Bible truth. It's very...
Preachers and organizers are constantly handing out Bibles to inmates, especially those with small copies of the New Testament.
Sure.
It is the one book nearly every inmate has in his cell.
Well,
go ahead.
Well,
okay. Well, A Man's Search for Meaning is another book that he had. I know you're going to say that probably. But, in solitary confinement, they bring the book cart around and they do have other books in there and he does have access to his tablets. So he should be able to read something other than the Bible. However, just because he's provided the New Testament doesn't necessarily mean that's the only reason why he could be seeking religion to help explain these extraordinary circumstances in his life. He could be looking at the New Testament. Maybe he was always curious about religion. We don't fucking know. So maybe he was always kind of teetering on the fact that he didn't know enough about religion, and he's got a little time on his hands, unfortunately, and he decides to study and look at different books of the Bible, different versions of the Bible, and decides that he's becoming religious, and regardless of whatever he's actually responsible for him and his conditions, he feels it's necessary for him to get forgiveness from this new found body of grace that he's found.
I'm calling bullshit on it, dude. I think this is something that's completely fabricated. I think that Richard Allen most likely grew up in a religious household, so I don't think religion was like foreign to him, where it's it's a completely new concept to him, and he's finding God. Like, I'm just calling bullshit on the whole narrative. I don't believe it.
When you're psychotic, sorry.
He was given the book A Man's Search for Meaning, yes, which is a book about.
I'm so fucking tired of hearing about how wonderful that book is. It's not wonderful. It's inappropriate. I'm tired of hearing about how wonderful that book is.
What a nice little gesture, you know?
Sweet.
Very sweet of her. Okay, there's another comment. Sleuth Intuition says he can be guilty and be confessing because of psychosis. That still makes him a child killer.
It's a very emotional argument. We're talking about law.
Okay.
Sorry, go ahead.
Well, I mean, this could be a legal argument. He's saying that, well, because State versus Nana Nana Boo Boo, 1964, says that you can say whatever you want and it's considered a confession. He could be, I'm kidding. Did you hear I said State versus Nana Nana Boo Boo?
Oh, sorry. I was laser focused on something else.
Okay, he could be guilty and be confessing because of psychosis.
Sure.
That still makes him a child killer. So for me, what makes him a child killer is whether or not he did it or not.
Right.
That I really don't think we'll ever know, because there is a difference between the truth and what comes out of trial. This case will not be complete in what? 3 weeks? A little more than 3 weeks, right?
Right.
Or I guess it's starting in 3 weeks, but it's like a 3-week trial, something like that. But like at the end of the year, like November, whenever it's scheduled to be done, it's not going to be done. This case is going to go on for a decade of appeals because of all these issues, these pretrial issues. He's going to have standing to get back in court. I think he's going to get found guilty. Sorry. I think that he's going to get found guilty. And I think maybe he wins an appeal in, maybe a decade and he gets out. Or he doesn't win an appeal. He just goes back through the COA process or PCR process every, couple of years. He has to, gets back in front of the court for evidentiary hearing or something like that. But, everybody go check out the All Eyes CCS, not the CSS, the CCS.
I'm gonna do it.
That shit rules.
You pop off while Oops, I'm gonna do it because I'm gonna do it. I know how I'm gonna do it.
Did you guys know? Oh, she already linked it. That's why I read it.
Oh, well, fine.
That's All Eyes for you. Like you were thinking, oh, I'm gonna help her, and then she already
way
did
ahead
it.
of me. Yeah, she's amazing.
It's ridiculous. Tell me about it. Okay, so did you guys know that All Eyes typed all those out? Isn't that fucking ridiculous? She must be a fast typer.
Oh my god.
She did it on mobile with all alt codes.
This is a great point.
If he is such a child killer, maybe his phone is in the geofencing. Or, you know what? Maybe it's not. Sleuth Intuition says catastrophe. Plenty of evidence against RA. Okay.
That's fine.
That's good.
Can I make a comment? I feel like this is my whole issue with confessions. If you are getting a confession from somebody 5.5 months after they've been in your custody, I don't give a fuck what that confession consists of, unless it yields like fruit that is something that we otherwise wouldn't have known or had. Like lead me to a body, then I'll believe your confession. Lead me to a weapon, then I'll believe your confession. But if your confession is just a confession after 5 months of being in the state's control and custody, then who's to say that your confession isn't completely contaminated? I don't give a fuck about his confessions. They're illegal. They were illegally obtained. Period. I'm actually so uninterested in his guilt or innocence as it relates to this argument. Like, it's not relevant. it's just not relevant, and it shouldn't be. That's why we have rules of evidence.
The court said they were legal. The court said they
What
were legal.
mean? The court, the Gull Court.
The court, yeah, the Gull Court said they were legal.
The Court of Her Honor. That's a good point.
We still don't know what they were, but that they're legal. So
yeah,
I don't know. I mean, I agree with you. I think it's they needed to prove beyond a reasonable doubt that they were voluntary, and by that standard, I don't know what you're pointing to say that it was proven beyond a reasonable doubt that they were voluntary. I think that, like,
are you arguing that when you're in solitary confinement, you can't make phone calls? Is that the argument? Sorry, Fiend. I'm trying to understand.
No, I mean, I think if you got a severe mental situation going on, or severe psychological situation, psychosis or something like that, I think that's plenty of reasonable doubt that you may not have made these voluntarily, which is all it takes. It has to be beyond a reasonable doubt. So Judge Gull making that decision, I think, is flawed, because I think there was tons of doubt that these were all voluntary statements across the board. Like, maybe I don't know. Like, maybe she needed to do more due diligence and look at them more specifically. But like, again, nothing specific was ever brought up. Like, you're not breaking these down and going one by one, like which ones to keep in and ones to throw out. But like, generally, like, there is tons of reasonable doubt that these may not be voluntary. Period.
Solitary confinement, they don't even use that word. It's called restrictive housing. It doesn't, like, the argument about solitary confinement is like a really, like, it doesn't matter. Like, okay, it doesn't matter what you call it. He's in isolation.
All I said, Sleuth isn't trolling. He appears to actually believe those things. He can take it up with Liggett and Holman because they confirm there is zero actual evidence against RA, only innuendo.
I'm so sorry.
Okay, so I actually agree. I don't think that Sleuth is actually trolling. I do.
Who said
really
Sleuth
believe...
was troll? Yeah, I didn't. I'm not.
Well, a lot of people say that, and that's their opinion. I'm not saying that they're wrong. I just don't believe that he is, because I've been an audience member, and so is Fiend, for a lot of his shows, and I do really believe that he thinks this is slam dunk case, which is, do it, believe it, it's fine. He's getting found guilty, so you get to be right.
Arguments. Make better arguments.
He doesn't have to. He can just say, it's the judge.
Yeah, it's not about.
But then don't be upset when you come into a chat where people are making good arguments and they uphold you to that standard. Make a better argument.
Say, your arguments are bad. The judge said that they were admissible.
There's not a lot of good arguments to make because there's no evidence, or like there's no facts to go off of. So I mean, that's the whole thing. Like, people can believe like Rick Allen's guilty, but like, you're doing it on blind faith. Period. That's it.
Yeah. Sure.
You believe in the state and you believe that he's guilty, and there's no evidence that points towards it, but you believe it, just like you can believe in lots of things without any evidence of them. Like, you can believe in all sorts of weird religions and stuff without any evidence that backs it up, but you can believe it and you have the right to believe it, but you're not going to back it up with anything because there isn't anything to back it up. That's the problem I have. Like, when you start making up things that clearly do not exist, then like, that's bad. That doesn't make any sense.
I just have a real problem with the fucking attitude of people that like are convinced of his guilt. Like, do they have to be so obnoxious? Like,
they don't know. Like, they don't know. Like,
well, they have to
they're obnoxious.
It's not a see. The thing is,
yeah. Tell me, Fiend.
Their
Tell me what the thing is.
Their blind faith would be they'd be fine on its face, but they that's the problem. They don't accept their blind faith, so they have to then have blind faith in like evidence that doesn't exist. Right. Like, and believe that there's this evidence that doesn't exist.
Right.
like that's to convince themselves. It's not going to convince anybody else because it doesn't exist. Like you're not going to be able, they're never going to be able to show it. They're not going to be able to produce anything. There's nothing to look at and actually like weigh as having any relevance to anything. It's all this like, I heard this and what about this? Or it could be this. Like it doesn't, it's useless, completely useless.
Yeah, I just think it's wild that like, oh, sorry, go ahead.
All I says faith isn't based.
I don't
on
even
fact.
understand why they're like, I don't understand why they're even like follow the case, because there's nothing to like look at unless like you just completely like make up fiction, which is what they do. So I guess that's entertaining. Fiction is entertaining.
I don't think fiction's entertaining. I don't remember the last time I read a work of fiction. I find
this is the whole fucking shit. You don't know. This is the whole fucking shit.
Hey.
Excuse me. Okay, so I think that we have a little bit of a problem sometimes with like thinking that people are arguing the same thing that we are. Like they're coming from this whole thing as like the judge said it, right? And we're talking about, well, like we're waiting to see. And if you're so diametrically opposed, it's really sometimes not even worth talking about. Like with some people, where if you can say, hey, the judge said this, and one of those judges was Judge Diener, who's not a judge anymore. We just read a little bit of Judge Diener as well, and I think that says a lot about him as a person. He's affected this case in a way that will never be able to be undone, regardless of whatever happens at trial, whatever happens in the appeals courts. He's had a profound effect on this case and probably these two attorneys in this, their approach to cases from now on too.
He's a fucking menace.
Yeah.
Is what he is. Yeah, because Diener is the reason that Rick was in DOC. And without Rick in DOC, they have no case.
Well, Diener is the reason. Like he's like part of the chain, right? But you also have Tobe, who's actually like decided to author this, and then you have Nick, who like, yeah.
Okay.
Why?
I don't think Tobe authored that at all.
Is that not a signature?
Is that a signature? What does that mean? I don't think he authored it. I think Diener authored it.
Okay, doesn't the statute say that it has to be the sheriff?
Yeah, the sheriff signed it, but didn't they say in the hearing that Judge Diener essentially wrote it and Tobe reviewed it and signed it, right?
Yeah.
Yeah.
Sorry, you're a piece of shit, Tobe. I'm giving you as much
100%. Oh, yeah. No, I'm not. You're not going to get any disagreement out of me about that. He's a piece of shit. He's spineless.
Well, that's my point. It's like, even though Diener is ultimately the one that drafted it and put it all together, I think that giving him 100% of the responsibility is taking away the responsibility of the person that could have said, wait, I didn't realize when I told you I read a Facebook post that I can't remember who even posted it is the person responsible for you going into solitary confinement in IDOC in Westville Correctional Facility.
For 13 months.
For 13 months.
But this is my issue with...
Stop shooting your fingers.
Okay.
Oh, go
this
ahead.
is my issue with the whole case. At every single juncture, there has been a person or an entity that could have and should have intervened and not looked the other way. And at every single fucking juncture, even before Rick was arrested, leading up to it, none of those individuals or entities did even the bare minimum of what their responsibilities required of them. And so okay, so then the blame lies on who? It doesn't fucking matter. I don't think it matters who the blame lies on. Like, correct the fucking issue.
I think who the blame lies on is the system.
Right.
I think that the system causes individuals to become callous to the decisions they're making when it comes to a victim, And part of that system was a tour of law enforcement speaking riddles and parables into a fucking microphone to people waiting to get any information they could possibly hear about this case. And you become like a character. Diener became a character in his own head. Toe became a character, and they all had to do what they had to do to make all this shit work. And they got desensitized. And quite frankly, I think it's kind of a clue to how they treat people in general in the system, and how they were so willing to make these decisions without any evidence, without this person having an attorney present, regardless of whether or not they were playing stupid tag with him and his mail, not getting the mail in time, or the canceled mail, all that stuff. Like him. I'm not quite sure how to help you with that. Oh, Diener knew that Richard Allen, the CVS manager, was going to be indigent. He knew he was not going to hire an attorney with the money he was going to get for selling his 2,000 square foot house or whatever it is in Delphi.
Right.
Right.
So go finish that thought for people that can't figure out what you're saying.
What I'm saying is
unconscionable.
Right. Finish my thought, Fiend. I know you love that part. It's unconscionable. That's a perfect word for it. It's lacking consciousness. It's the smartest thing Fiend's ever said.
What changes systems?
3 YouTubers that have said the same stuff every single time they talk.
Aside from the 3 YouTubers.
Oh, okay. AI art like Fiend has here.
Yeah. Right.
Okay, the system I think is only the system here is really designed, I think, to just swallow up somebody in his position whole without little recourse. And you'll see in cases where you don't have a Diener or you don't have a goal, people are allowed to make more of a record. People are allowed to make an argument. There's a fucking Frank's hearing. Okay, let's say the Frank's evidence sucks. Let's say it's not going to be able to get a search warrant thrown out. Okay, it's not an omission, and it's not a glaring enough omission to change whether or not there was probable cause for the search warrant. But the judge having the information that's in the search warrant, saying that she didn't read it, and then offering another search warrant means that she had a different standard for people that were going to file a Frank's hearing in her own court. And to me, that she should have offered a Frank's on the first Frank's and let them make the record.
Yes.
Let them take some time and do it. But then what do you have? You have a record of her hearing everything, reading the Franks, maybe some legal analysis, and then a denial.
Right.
Maybe that's actually worse for your appeals, because you may be able to appeal this in a way that is more effective when you have all of these just blanket denials across the board. It is problematic probably that she doesn't actually give a lot of legal analysis because there's not a lot to push back on, but that means that what she has said stands on its own and there's not much analysis that can be done because she didn't provide enough. So you just have to look at what she said, which I don't think is that favorable when you're just looking at pure bias, like in a pure bias argument. Oh, right. Thank God.
But you can't appeal a conviction just based on like some bias, not successfully.
Well, you can appeal it based off the rulings the judge made, and you can point to her ruling. Like, okay, for instance, if you can prove that there was some type of, for instance, the Diener COA.
Mm-hmm.
If you guys are not familiar with this, Diener's being a fucking weirdo. And then they're like, okay, that's not going to work. You can't be saying all this weird shit. It seems prejudicial and inappropriate. So we're going to find something to reverse you on because you're an unhinged fucking weirdo, basically. Okay, so let me just go over here. Sinbad Sailor. Wasn't Alan's house worth at least $250K? Couldn't his parents help out?
It's a weird question. That's a very weird question.
Well, I think it's it's a question that really expects a lot out of a person.
Yeah, it's an interesting question. Is probably a better word.
It asks a lot of a person that's really never been involved in the legal system, as far as I can tell, for Alan. So, wasn't Alan's house worth at least $250K?
I don't know. I didn't look into it.
I think let's say it's $250K, right?
Okay.
What does that get you in a private attorney? This is not. Well, I mean, what is the state even going to be able to do? There's a whole thing where it's like, usually in these cases, like, there's systemic issues, obviously, in this country where people are usually involved in dangerous, illegal activity that could result in death, that are on a socially, like, more on a lower scale, right? On I did hack you. I DDoSed you, dude. And then I got your IP from YouTube. So
we're back to this. Okay, sorry.
They're like on a socially more economically disadvantaged area, usually when you're in that getting charged with murder and stuff. So like the state doesn't really want you to hire a private counsel because they know better. They know they're going to just have to replace your private counsel when you run out of money. So if there's $250,000 and he's getting I think he got charged with 4 life without parole eligible offenses.
Yeah.
He's going to get charged with, or he may get found of quadruple life without parole. And you think that there's no way the court would say, okay, well, $250,000, that should cover everything, because it's not. What are they going to do? Are they just going to say, oh, well, he doesn't have enough money for an expert, or he doesn't have enough money for these transcripts anymore? Like, he's broke because these attorneys took all his money. So then are they going to give him private, or then are they going to help him with, public, they're going to re-sign in public defenders? What if they wanted the death penalty? Can he afford a death penalty lawyer? They're like $127 an hour in Indiana compared to $100 for life without parole eligible defense. So I just think there's really probably no way that Diener thought that Alan was not going to end, or thought that Alan would end up with private counsel. Yeah, this isn't a DUI. This is huge money. This would be an absolutely astronomical amount of money. And you have these 2 attorneys who get hired, right? They're being paid $100 an hour. A lot of that is going to the infrastructure of defending him, because the reality is they're hiring the law firm at $100 an hour, basically. It's not the same law firm, right? So to contrast that against McClelland's resources, he has the entire state police, right? He has a secretary. He has a court clerk. He has fucking Mullen, right? He's got a really dope, expensive Cellbrite server. So like, when Nick goes all the way to Allen County, like, he's just going to grab his costs. He's going to take a state vehicle, right? He's going to maybe drive his personal vehicle. He's going to give his fucking mileage right over to the secretary or the clerk or whatever. And guess what? She's going to enter it into the state reimbursement system, and then it's going to go through, and there's going to be a claim filed, and he's going to get paid, right, for his expenses. These guys, they have small law firms. They have to do all their own billing to the state. They have to hire their own people. They have to, pay for these programs that they have. It's not the same thing as just like when people are talking about systemic inequality between indigent defendant and the state, the key word there is systemic.
Right.
Like, there's a system in place that is designed for the state to maximize their efficiency in exerting punishment over criminals. Okay.
Right.
And they have it very easy when it comes to everything that they have going on. And these attorneys probably went in like, yo, $100 an hour. This is a pretty big case. I don't know how the fuck we get assigned to it. Let's go check this shit out. And guess what? If the case sucked, they would probably, do the best they could for the client. But no, they probably found that there were some interesting issues that they wanted to look more into. When they started looking more into those interesting issues, they started finding other issues. They started finding legal opinions, maybe legal avenues that they had to be able to overcome the arguments that they think the state was making, and they thought their case was weak. And so they got more and more involved. And as they got involved, they probably thought, this is just the case that we really want to stay on. And they're probably giving a giant discount to the state to be able to even work this case. Because there's probably expenses that they're not reclaiming. There's probably stuff that they're not accounting for. Okay, we have another comment here. Curious Luke, 93. Another comment. Curious Luke, 93. There are 5 witnesses, all female, according to the PCA. 3 including 3 girls that Alan said he saw. Yeah, I don't know. Like, I'm sure you've heard of a police lineup or a 6-pack. I don't think they, usually witnesses will be able to identify somebody.
They didn't use a lineup for Rick because they knew no one would be able to fucking put him out.
Oh, but
You
they
think
drew
they did?
pictures. They helped draw pictures of him.
Apparently, but none of those sketches are of Rick.
But Holman
Are
said
they?
they were pressured, right?
Hey?
Holman said that the witnesses were pressured into participating in the sketches.
I don't know what Holman has said.
Well, Holman said that. It's in the transcripts.
I believe you.
That's interesting. Okay, from the sketches, there are pressured into doing Hansi Bay. Hansi Bay, I love your avatar, Hansi. I know. Hansi's secret. But I'm not going to say it.
You better fucking not.
I'm not. It's fucking HIPAA protected. I'm not going to fucking
Okay, thank you.
break the sanctuary state we have here.
Who's on panel? Who are you?
I'm the 3rd executive burrito boy of my name.
He doesn't recognize your voice.
Yes, see, whatever that means. Okay, this is kind of spitting. That's really it. Yeah, I just don't. There are 5 witnesses. Yeah, well, there's 61 witnesses actually. So there can be as many witnesses as you want to imagine.
I am just
fried.
Fried? I'm fried, but I'm also fried is a good word.
Okay, we can call it if you want. Is that what you're about to say?
I was gonna say a thing, but we can also.
Okay, never mind. No, that's fine.
No.
I never even wanted to call it one time. I wanted to say this before you say anything. I'm gonna say this. Okay. So, how tall is Richard Allen? Do we know? We don't fucking know. Some would say he's like 5'4", right? 2'5'6". Okay. Does anyone know? Did he wear inserts in his shoes?
Yeah, lifts.
3'2". Well, I've heard 3'2" actually. One of those pro defense channels. Did he wear lifts?
Yeah.
Does anyone know? Does he like tall boots? Who knows? 5'4". I'm 6'8". Okay. I think we talked about this before. I'm 6'10".
Yeah, that's true.
10. I'm 6'10". So I'm taller than whoever's brother they were talking about the other day. One is taller than your brother, remember? I can't remember who it was, but how this man's face is covered, right? This man apparently was looking down. They all describe his clothing differently, but I see somebody and interact with them and you see that he's a 50-ish year old man. Do you think you wouldn't describe them as short?
You would 100% describe him as short.
That is so short that anybody who came into interaction with him that has ever seen an adult American male would say that he is likely shorter than an adult American male.
Right.
IDOC does say he's black. Yeah, Athena and I need to get down to the bottom of that. What's up with that? Yeah. Sorry, RA, dude, you're short, bro. And that might fucking work out for you. That might be really beneficial to you for once. And I think I've said it a million times. I don't think you could tell how tall fucking BG was.
Why do you say that? Why do you say that?
Okay, because does anyone have a hat? Have you guys ever had the opportunity to own a hat? Okay. Have you ever put it on your head? Have you had the occasion to wear a cheeky little hat? Okay. Now, have you worn shoes? Have you worn shoes? Okay. Have you worn puffy socks? Maybe your socks make you taller. Maybe you got some really puffy ass socks. I don't know. Say you're wearing boots. Okay. He was in the National Guard. They have, some people like boots after they get out of the military. I wouldn't know.
I wear boots.
Okay. Nice.
You asked.
So they like, tall boots. They're like nice tight boots, right? Tall ones. Combat boots, maybe. I don't know. And
sure, tight boots.
Tight, puffy
tight
socks.
Boots, puffy socks, tight boots. Okay.
Okay. And we know that there's like, you got some Converse All-Stars, right? Or you got some boots that are like the sole is very thin, right? So you could be just your boots, right? You could be anywhere from, I don't know, maybe a half inch. You hold a half inch up here. Half inch. That seems like an awfully thin boot. Maybe 1 inch thick boot, right?
Yeah.
Or shoes, or whatever the fuck. Or you have like, I don't know, 2-inch boots, right? But then you have a hat on. Okay.
Yeah.
And so right there, let's just say low end, you could be 1 inch to 2 inches. Okay. Just the boots. Okay. They have a hat on.
Just the boots? Okay.
Yeah, and the difference of the size of the boots. Are you kidding me? Go to the store.
1 to
put
2
some
inches.
fucking boots on.
Okay. Go ahead.
I wear 3-inch boots, so I can be 6'13", also known as 7'1". So you have a variance in that, right? And then you have a hat. Well, is he wearing a hat? We don't fucking know. But if he was wearing a hat, if you had the occasion to wear a hat yourself, you'll know the different hats fit differently. Okay.
The occasion. Yep.
Yep. So there could be a situation where you're wearing your hat a little higher, you're wearing your hat a little lower, and the video is so blurry that you really can't tell if it's a hat or not, right? Can you tell if it's a hat? Is he wearing a hat? You don't know.
It's
right?
a hat.
It's a hat. Okay.
In my opinion, I think they can tell how tall he is.
Okay, so
with a degree of.
Well, I'm getting there.
Okay.
This is very scientific. Okay, I've talked about the puffy socks. All right.
Yeah, 7'1". Keep going.
Okay, so just say you're wearing a hat that you're like kind of, that's not like a trucker cap, right? For a male.
Yeah.
There's some air in there, right? Who knows? So say there's like 1.5 inches. Your hat could be like 1.5 inches taller than the top of your head, right?
All right. So
depending on how you're wearing it.
I'm keeping a running tab. Okay.
3 inches, right?
Yeah. Mm-hmm.
Okay, in any direction. So it could be 3 inches higher or 3 inches lower than.
Wait. Okay.
Well, no, I'm not there yet. Sorry, I gotta make up some more measurements here.
Okay.
Okay, so say that he's walking, right?
Mm-hmm.
Now his legs are spread out, like he's not standing up straight.
Yes, because of the placement of the tiles. He's not walking like he'd normally walk.
Well, when you normally walk, you're not the same height. You ever seen that? You ever seen people that heads don't move when they walk? That's kind of
I like
unsettling,
to
isn't it?
crouch walk. So
Yeah, no one can ever tell how tall you are.
I like to crouch walk. So maybe that comes into play.
That's how I got on the plane.
Yeah. Mm-hmm.
When I boarded flight 705.
Yeah, you had to crouch.
I crouch walked. I'm actually
Squat walk,
6'13".
Yeah.
Okay, so let's say he's like taking a big step. What? That's what I'm saying, man. Devil's advocate.
Okay.
That's fucking genius. Precocent. They say she's a hacker spy, but she's really just kind of funny sometimes. Okay, so if you're walking and you're taking a stride, are you a little bit shorter? Maybe. Okay. Now the phone is, I think personally, it's cropped pretty significantly, because if you look at the resolution of the photo or any still image, the resolution does not make sense. And the resolution makes more sense if it's cropped using even a lower, like maybe 720p camera.
That's what I was thinking.
Which is the frontal camera.
Yes, it was a front take. So you can also see, I wonder if this would also affect like the focus and quality of the bridge guy image, because Abby's in the original image in the frame and she's closer. So it probably is like, you know what I'm saying? It would be very out of focus, I imagine. You know what I'm saying?
Potentially. And I don't believe this is like kind of a niche theory that we don't really, not even a niche theory. It's a niche, like, potential set of circumstances that I don't know if is really possible, but let's say that they actually recorded it using Snapchat and then downloaded it. There could be other, like if she hit download on the Snapchat before it's posted, back then you could have a video that was longer than the time. Anyways, yeah. So what height is she holding the camera? Is she standing on a rail? Like the railroad has like the ties, right? And then it has the horizontal ties and the parallel ties that go down the whole bridge. I think people that actually bend the bridge, unlike some people, they say that the ties are about 6 inches thick, right? So if you were standing on one of the ties, maybe they were standing on one of the ties, maybe they weren't, maybe they're on the ground, maybe one of the ties he's standing on is higher or lower. You have a degree of like wiggle room in there, right? So I think you can get like from a range of like 5'5" to 5'9" or 5'10". Okay. And you think, okay, it's 5 inches, right?
That seems like a lot, but yeah.
But like, okay, so say the variance is 2.5, right? Well, the middle would be 7.5.
7.
Right. Yeah. But then you're thinking, oh, it's so 2.5 inches in either direction. That doesn't seem like much. But that would be huge if you're adding them together, because everything is like very low on the actual height. But in reality, so it could be like literally a 5'5" man versus a 5'10" man. That is very different looking, standing next to each other. It's very fucking noticeable. Now, if you put those kids or whoever they are, minors, women, 5 kids, 5 girls that's seen him, you got to think that they would be able to say that dude is short.
Yeah.
That's my point. That's all I was saying.
I agree. I think you make an excellent argument. I just feel like there's got to be scientific ways. Like we can do a lot of things. I imagine there's got to be ways that they can, with relative with some variance, determine how tall Bridge Guy is. And I think
No
it's
way.
very... No way.
No.
Okay.
Because I say no way as in like I'm saying that my opinion is no way.
No, I understand.
Like I'm not saying that you're wrong. I'm saying that my opinion is saying
like,
that
no
you're
way.
wrong.
Sure,
No,
no,
it's
I
saying
know.
that
In your opinion, there's no fucking way.
No, not in my opinion. The opinion that I've obtained and I possess, not necessarily belonging, like it's not my opinion, it's just what I've acquired, right? Says that no way. Because how it's usually done, and this is something that's like people will take like the forensic photogrammetry and apply it to this situation, but they don't realize that one of the most important things about forensic photogrammetry is the backdrop. Usually one of the reference points is something that is directly behind the person. And you really can't do that because in this case, it's the nature and the trees. And so you would have to know exactly how high the phone was and how, the angle, what was cropped.
What makes you think they don't know?
What do you mean? Like how high the phone was?
Yeah.
Well, I mean, say that's like 6 inches. Like she could be holding it 6 inches higher or 6 inches lower. It's going to change the field of view.
Right.
Like, or it's going to change the angle that the camera is taking it at. And there's the aspect ratio of those old phones. Like there would have to be like some type of correction for the way that the further you get away from the center of the camera or the center of the image that's captured is calculated. Plus, one of the other things is when it comes to taking a video here, there's something called frame interpolation or interopolation. So like in a digital recording process, they are taking a video, like normally is you think of a video as just like a bunch of fucking pictures, right? The images. Well, a video, depending on the codec or like the format or the way that it's stored or recorded, there could be frames that are created by mixing two frames that are a distance apart, like say they're 0.25 seconds apart. There'd be a frame in the middle that's created by the camera program or the hardware that allows the video to appear smoothly. So like when you hear like 60 frames per second, it might not be that it actually took 60 images. Like there are frames that are interopolated, right? And like they can be to make it look smoother. But that means that there are some things that can be frozen, like if you're taking the actual just screenshot, and saying like this is how I'm gonna measure this guy's height. That might not even be like a real picture. Like you may be actually measuring from an interopolated frame, which the forensic photogrammetry articles will say that they try to do their best to make sure that they're using a known frame and not an interopolated frame. So they'll like digitally parse the frames out and examine them for signs of blurring. Yeah. Because it's about motion, right? And if you have a slight blur on one of those frames that are in between actual images, it may appear blurry more around like his head. And that could even account for some of the pixelation. Like if you're taking one of those pixels or like one of the larger like reconstructed pixels that are in the cameras that are like a larger square that you can't really tell, there's like no consistent line, is like the person's head could be at the top of the fucking disoriented pixel or maybe like an inch down. And there's nothing behind it that you could actually take as a reference point. So I think it just goes to like literally you have to look at the video and go, okay, the bridge is about this fucking wine, and you just have to judge based off from like your, and it sounds stupid, it's not scientific at all. I'm just saying, like, this is how most people will process it. How tall does the person look on the fucking bridge? Like, that's usually what it's going to come down to if you can't do it scientifically. Because if you do it scientifically and you have absolutely no correct methodology for the calculation, in your head, you're saying, well, this is a free forensic fucking measurement of this guy. So it has to be correct.
Right. I don't think the video helped anything.
No, I don't think so either. I think I do wonder sometimes, like, what if we could go back, and this is like stupid fucking fan fiction, I guess you could say, like, much you want to say fan, it's really stupid. But if you could retcon this, and if you could take the sketch away, all sketches of the one guy, I guess, right? And you took the photo away and the video away, do you think this case would be solved faster? Or like, let's say that they would eventually arrest RA regardless, like, because I don't think it really has anything to do with the sketches anyways. Do you think the case would be different? Do you think they would have ended up stumbling on RA, or do you think it was just a very, very effective distraction? Not as in like they were motivated to distract, but
it ended up being
just by the nature of it being an image was distracting.
I believe that if we didn't have the image or video, I don't really put too much into the sketches, but if we didn't have the video of a bridge guy, there'd be even less like confirmation bias, I guess, because half of the PCA is how he's the man on the bridge, he's bridge guy, and they don't have to prove that at all. You could literally say this investigator believes that the man in the video is. I mean, that's a huge part of their case, and it's useless.
Well, some people will say it doesn't have to put anything in there. I just gotta get
You just explained to me for 30 minutes why it is useless. It's
the video or the PCA?
Well, both. But I mean,
minutes?
What?
Was that really 30 minutes?
No.
Did I enter
It felt like 30 seconds, honestly.
That's lovely. Okay, so this guy right here says those girls seem to be pretty accurate.
How do we know?
Oh, yeah. I would say, I don't know if they're accurate or not, but I think if you do exclude some of their statements, you could get probable cause to make an arrest. So I think if you say this is accurate, right, based off what you've seen in this video and what this guy said he was wearing, yeah, certain things that they said seem to be accurate because you think he did it.
But they said he was also wearing all black. Didn't they at one point say the man was wearing all black?
Yeah, but that was not accurate.
Right.
That part was not accurate because he wasn't wearing all black.
I gotcha.
You know what I mean?
And it could only have been one. It had, and everybody that the girls saw, that it was all the same man. It just had to be.
Oh, yeah. Okay, so Yellow says, girls saw a guy a mile from the crime scene. Blair saw somebody who deaf was an RA before the girls allegedly walked up. Throw it away. Yeah.
Oh. Yeah, the PCA is useless.
Mr. Sailor says, witness RV says the man they saw was not very tall. Definitely not taller than 5'10".
5'10" is quite tall.
Yeah, so for me, like, I get that people will use this as an argument to say why they believe a person could be guilty. However, the only thing different I'm saying is I just want to hear that.
Hear what?
I want to hear the witness say that. And I want to hear the
Like
witness
from
on
their
cross-examination.
mouth. Yeah.
Yeah, because, like, He said, witness RV said, the man they saw was not very tall.
Right.
Definitely not taller than 5'10". Like,
Yeah.
I would like, for me, it's more of a me thing. You know what I'm saying?
This is like a me thing, not to be nitpicky, but this is just like a me thing.
You can do what you want to do.
Right.
I just want
As
to
far
hear
as I am concerned,
the witness RV say that. And I want to hear them be cross-examination or during cross-examination. Okay. If they were so accurate, why didn't they use Rally's sketch? Oh, because parts of it to describe the killer's face, they didn't think it was accurate. As a former teenage girl, I wouldn't trust my eyewitness account, Sinbad. Like me, as a former teenage girl myself, I would have a hard time believing my own thoughts.
what 14-year-old girl is going to say he walked with a purpose?
Yeah.
I mean, I might have.
You would.
I would. But like,
you try to be a little reporter. Hi, I'm Helen.
You think I'd talk to cops?
Even back then, you were down for the cause.
I was not talking to cops at 14.
Oh, did you smoke cigarettes when you were 14?
I did a
cigarette. Did you do a cigarette?
I did a cigarette. I had done it.
I'm writing it down in my little red notebook.
I did a cigarette by 14. Get out of yeah. No, I wasn't talking to cops. But this is another thing that is infuriating to me. The state's not destruction of evidence, the state's either not logging and documenting and not retaining or losing evidence, like literally is the only reason that they have, like, how is it possible that we still have such a difference in Rick maintains that he left at 1:30, right?
Okay, so this gentleman says, we don't need the witnesses. Alan put himself on the trails and on the bridge between 1:30 and 3:30, plus the 60 plus confessions.
This feels like it feels like you've been programmed, because Sinbad has really good arguments sometimes, but it's like this, like something happens, it's like this, like cognitive, like this, it's like something happens where like it's like a frustration trigger where like it's like all argument, like reason and high level discussion and argument seems to just erode and deteriorate, and we revert back to these state given talking points that are absurd. I can't believe that we have put somebody in solitary confinement in a state prison because they said I went for a walk that day and I happened to be on the trails. Like, that's enough for you, Sinbad? You want to convict this man?
What? So he said, we don't need the witnesses. Alan put himself on the trails, on the bridge between 1:30 and 3:30, plus 60 plus confessions. Okay. I read it. Okay. He also said, witness RV said the man they saw was not very tall, definitely not taller than 5'10". Let's see what else he said, because I think he said something else. Those girls seem to be pretty accurate. Okay.
Based on what?
She described him as not very tall with a bigger build.
We could like just pull up the
he
PCA,
was not. He was not bigger than 5'10". RV advised he was wearing a black hoodie, black jeans, and black boots. I'm not going to keep going.
That's not consistent.
But that's 4 comments that you made about witness statements. And that's fine. I understand those were in the PCA. Now I'm going to go back, and you said we don't need the witnesses. Okay. I think that you do need the witnesses, but maybe you don't. But then why are you using them to support your argument that it's more incriminating that these people seen him? Because if he put himself there and he confessed 60 times, then why do we need even his statement, like putting himself there, if he's confessed? Why do we need to even enter the evidence of the girls if he's confessed? His confession alone should have enough information that's incriminating that only the killer would know, that would be enough to secure a conviction.
Weak
So,
sauce.
like, why start taking stuff away? Like, you don't need the witnesses. Well, you don't need him putting himself there in those statements either from back then. So you just go with the confessions. He must have said something bad enough to, like, maybe he said it again. Yellow says, no recording at interviews from first 6 days. And I can't with these fools. Yeah, I'd be doing it with these fools sometimes, though. Where are the SOPs, standard operating procedures? What have they learned from their mistakes? New recordings from any of the last crimes past 5 years? Well, you don't get to make that mistake again because it's over. The case, I would say the case is over, but it's not. I guess it's not your normal situation. What about the 70 days of interviews?
I can always tell who's a cop.
You think someone's a cop?
I can smell a fucking cop. What? I didn't say a name.
Oh,
I'm just saying I can always tell who's a cop and who's not a cop.
I think Sinbad has a different perspective than me.
I didn't say anything about Sinbad.
Well, I'm saying about Sinbad, and I also think that selection bias, survivorship bias, for sure. Like, if you're only looking at the statements that made into PCA, that's called survivorship bias. Like, you're only looking at what has passed muster to be usable as like the standard, and yeah, that's not the move. And another cog by cognitive bias. I can't remember. Okay, hey, I'm just trying to wrap it up on my channel here by reading everything. Not wrapping up reductionism and lunacy. I don't think it's lunacy, honestly. Like, these are normal takes, guys.
Well, actually,
I think they're pretty, like, this is a pretty normal take. He's talking about what the state put in the PCA and fucking how he thinks it's legit as fuck. And that can be done. Who? Okay, I'm going to tell you something about this case that really fucking irritates me. Guys, I cannot tell you how many times I have heard one of you very people in this fine chat here say that the PCA in this case sucks, right? You should look at the PCA against Brian Kohlberger. That's an example of a good PCA. That means that he's fucking done it. Okay, how many people have said that? Be honest in the chat right now. Have you ever used another PCA to determine whether or not somebody is guilty is an example of why this PCA is weak? Be honest. Don't let Sinbad distract you. If he asked you again, real PCA. See, Catastrophe said it.
I can't hear you. Can you repeat it?
What, my question?
Yeah.
Okay, my question is, how many of you people have you fucking people? Listen up. Sit up straight when you're listening to me. How many people have you heard, or how many of you have made the argument that the PCA in this case is shit? Because if you look at a real PCA like Brian Kohlberger's, that is an example of a real PCA with the timeline. They got the timeline. They got this. They got that. They got these fucking witness statements of the bushy eyebrows. They got all this shit, right? Like, I've heard that so many times. Guys, that's just what the cops said. It's the same thing in this case as it is with Brian Kohlberger, as it is with any criminal case, any case. It's the theory of the crime. Whether it's proven or not, we don't fucking know. Who knows what's actually going to happen? But, like, making the decision based off from what's in the PCA, whether somebody's guilty or not, and then, like, using another PCA to be like, this is really what it's like. How do people not take the state's word for it? And I'm not talking about the state of Indiana. I'm not talking about ISP. I'm talking about the state, right? The government. How do you take the government's word for it in another PCA when you've seen in this and you've learned in this that it's not just this case, but that the state's theory often is not something that you should take at face value, because that's not how our system works. It's not how the criminal justice system works. It's an adversarial system. Rex Heuermann's bail application. Now, what I'm not saying that like they're equal, as in they are, one can be more valuable than one can't be more valuable than another eventually. Like the fucking bail application for Rex Heuermann, dude, you cooked. Okay,
yeah, it's good. Yeah,
it is fucking extensive, and like in comparison to this one, yes, there's a difference, right? But my thought is you shouldn't necessarily use another PCA as like supporting the fact that this PCA is weak.
Right. You're comparing you're comparing two yet to be proven low burden theories.
Yeah.
Saying that like one sounds better than the other.
The other PCAs have so much better stuff in them. Well, yeah. See, you just did it again.
Wait.
DV, you literally sent me the list and said, look at this compared to Delphi. That's okay. So I'm saying like that I can do that.
Yes.
Okay?
Right. Natural.
And that I'm saying I am without flaw. Okay? I cannot be held accountable for something.
No, you're infallible.
It doesn't apply to me. Yeah, I'm infallible. Okay.
Right.
So my point is, I just made you a mod woman. I will unmod you so quick.
You will. The Lord give it. And let me tell you
And
something
the
about
Lord
hardcore.
take it.
He take it. He taketh away. You think you're flying high. Next thing you know, wrench gone.
Also, I want to see proof of that.
Of what?
I want to see proof of these comments that I've made about a fine man, a good man, Rex Heuermann.
A reverend.
A reverend of a man, Rex Heuermann.
Yeah.
A good man, a fine man, a family man. How dare you? He had some issues, but whatever. I still think, hey, dude, prove it. I still think there's some shit in that fucking bail application and during that first press conference that looks a little sus. I still think there's maybe some other. Oh, read that one. Okay. You will randomly lose your wrench with no notice because somebody's co-host's wife hates you. That you have a strong opinion on Karen Reed. No.
Hypothetically.
Damn, I thought the husband would be the issue there. Okay, Tammy Martin says, Karen Reed, never heard of it. Case examination of all cell data, including law enforcement, family members, created a mistrial. Carroll County doesn't give a shit about the extra cell phone data. Next crime scene. Look the other way. Look the other way. Yeah, I mean, I have a lot of questions about the cell phone data in the Delphi case that I don't think are ever going to be answered because we don't know what they did. And I don't think we'll ever know what they did. I think there's probably going to be some stuff coming out of trial about the subpoenas about cell tower dumps and the reasons why that Rick Allen's phone's not there in the original geofence. It's because it wasn't a fucking geofence, dude.
How do you know? You keep saying that. How do you know?
How do I know that they didn't do a geofence in 2017?
Yeah.
Because fucking Ives called it a subpoena.
Right.
Google doesn't give out shit for a subpoena. You have to have a search warrant.
But Ives wasn't the only one submitting for that. Like they had the FBI was there doing a lot of that for them. So who's to say that the FBI didn't submit their own?
And then it's gonna be used at trial.
Well, I don't know how any of that. I mean, you would probably tell me that that's not going to happen.
Well, I would tell you that it would be quite the process.
Like a 2E process?
Yeah, it would be 2E. But they would have to probably litigate it. But also, I don't think they've had a particularly difficult issue with getting information, because I know that Auger came in to
specifically
help with some of the TUI stuff, but I really don't think she had much of an issue, and that's either because they didn't have shit, they didn't do shit, or for some reason the FBI just completely cooperated. Yeah, all I says
I
I
could see
submitted
them
subpoenas.
maybe cooperating.
Yeah, so cast. People say cast. Well, when did the FBI actually get off the case? And I'm not talking about the JTTF task force agent, and I'm not talking about the 3 agents. Yeah, the Geofence wasn't until 2019, and that means that they did a Google Geofence search warrant in 2019. It would have had all the data that was still there and accessible from 2017, which most likely would have been everything, but it would have been way more people than tower dumps, because there was, like they say, there was only 2 cell towers in Delphi, right? Well,
Right.
that doesn't mean everyone's connected to those fucking towers. The tower range back then was anywhere from 30 to 50 miles.
It's a lot.
And so, yeah, if you wake up, if you charge your phone overnight and you like turn it off, turn it back on, and like pull your phone out, like you're probably going to connect to a fucking Delphi tower.
Right.
But say if you like go visit your mom in Peru, like 45 minutes away, and there's 10 towers that you could be handed off to on the drive to Peru and back,
You'll still be stuck on one of
you
them.
may be on one of those towers still. And if you do a subpoena for the 2 towers in town and not a geofence, you're not going to get the data from those people that are seen on the subpoena. Or sorry, you're not going to get the subscriber information from people outside of those towers. 18,000 lines, which really is, 18,000 lines is manageable, honestly.
Yeah. So if they did it,
offense to U.S. Marshals.
Vito's a marshal.
Vito?
Mm-hmm.
He's ISP.
Yeah, but he's with the U.S. Marshal. He's something with the Marshals. I promise.
Oh yeah, he's on the CIC task force, I think.
Yeah, and I looked up some of his. I'll send you some. I looked up some of his like past cases, and he does a lot with some of like the more. I don't know if it's something Stingray specific, but he's done a lot with cell phone stuff. I'm not saying that like that necessarily has anything to do with anything, but he came in 2020 related to the Kagan investigation, and obviously that led him to the Unified Command Task Force. I just feel like they probably have done. So like if they did a geofence in 2019, then they have then they have a geofence.
Yes.
Okay. So does it make it? I'm genuinely asking. Does it make a difference if they did it in 2017 versus 2019?
Most likely not.
Okay.
But there are people that have a different theory.
Like
well, that certain types of cell phones wouldn't be in the geofence.
Right.
That's just not how it works. And like
they'd all be.
Yeah.
Yeah.
Yeah, because what people don't understand about geofencing, amongst a lot of things, like
everything.
We're all true crime fans here, right? So we're talking about
Not me. Speak for yourself.
I'm not a true crime, but not ready to go that meta into
Okay.
with this discussion. But like we generally, like, people who follow these cases are like, well, it's like a law enforcement tool, right? No, it's a marketing tool. Capitalism. You think you think the court systems are powerful? Y'all should know about fucking the effort Google goes to targeted ads for your device.
It's really fucking scary. It's unsettling.
Well, that's why the whole thing exists, because they want to know geographically where you're at.
Right.
And they want you to know, they want to know what they can sell you, and they want to know the conversion rate of the ad. They want to know who you are. They want to know where you go.
To do a consumer.
They want to do you consumerism. And
yeah, they do.
me, myself, I'm a consumer.
You are their prime target. Yeah. They want you. They want to get you.
I'm very materialistic, guys, if you didn't already pick up on that.
It's a material girl.
This is a $25,000 microphone I'm speaking into. I actually sell
it. It's $25,000. It's correct. It's a quarter of Nick McClelland's podium.
Yeah, this is exactly right. Psychographic marketing. XOXO. Right back at you. So yeah, psychographic marketing is like when they're looking at your, your actual, it's like a little bit and further and more elaborate than like your actual demographic style marketing, but like your behavior, right? I'm sure you two can explain it better than I could ever explain it, but I'll just take over that. Okay, so like it's designed to know where you're at and like follow you around and shit, right? Well, it's not really designed for law enforcement purpose, but like people found out that you can actually fucking use it to like find out where people are.
No
like
way the government exploited the vulnerability.
Yeah.
No fucking way.
Yeah. So the
it's because he's lounging, woman. He's lounging.
I do be lounging.
He's staring at the ceiling, talking. Just picture that.
I can't hardly hear you. Get your money back. What happened to this? Let me turn you back. How does that sound?
So much better.
Okay, well, I guess I had to point it at my face and not just stare at chat, waiting for somebody to talk shit. I was actually looking right at the monitor. And my microphone, believe it or not, is not inside of my monitor. Crazy. Okay. This chick said, I've missed so many comments because I'm working on my CCS like a nerd. We all very appreciate the fact that you're missing comments because we need you. We need you. Oh, thank you, Meow. That's very nice of you. If I had this voice and I said stuff like, oh, no, they seem pretty accurate, the teenagers. I actually believe 16 teenage girls that heard 61 confessions. Is it as soothing? I don't think so.
It'd be a problem. It'd be problematic. Who knows where I'd be?
Probably 6 feet lower than you are now.
Sitting next to Sleuth Intuition, probably 6 feet lower for that.
Well, what you think is, what you guys don't understand is that the defense wants you to believe that a bunch of Odinists did this. And
so they can write their books.
They want to write a book. Yeah, because that's really lucrative these days, you know?
Yeah.
Everybody's self-published to Amazon.
Books by defense. Yeah. You can get most books for free on like Amazon. Just gives them away. They're like, please take this. They don't.
Yeah. Or you do what I do, and I go to a dead mall. There's the Barnes and Noble still open. I just steal them.
Yeah.
You just walk out with a book. You know, I'm a 97-year-old white man. Like, no one's stopping me, dude. Okay, CastViz software updates, I guess. Haha. Well, interesting thing about CastViz, it's literally just started as an Excel sheet that imported data to map. Like, it's literally just dots on a map. But then over time, they like developed it and like actually did a like a PO from
they did a standardized
software. Yeah.
They did a thingy with it. They made it into a thingy.
They did a thingy. Which I'm totally I appreciate a thingy sometimes.
When is your book gonna be finished, DB?
Oh, well, I need to get more crayons.
Yeah.
Are you talking about my coloring book I've been working on?
Yeah, that one in your life, your autobiography manifesto. Yeah.
I thought you said you weren't going to mention that on this.
Well, I lie.
Anyways, moving on here. What's the Geofence? Oh, I already read that. Jenny, hee ha ha ha, like that. That's cool. That's hip. Whatever the fuck she said. Fucking woman doing whatever the fuck. I deputized for $20. Okay,
Who's
well
in
I
her
got.
picture?
Huh?
Who's
I
that?
don't know, but
Who's the hot
dude,
nun?
dude, why does the hot nun have your eyebrows? Wait a second.
Hashtag what? My eyebrows?
Yeah,
I don't know, but she's sexy.
they did. You talking about all eyes?
Yes.
Okay. They did focus on 3 devices out of 18,000 lines, though.
How many devices were in the 18,000 lines, though? Like 18,000.
Not 18,000.
Right. So, like, how many lines generally, on average, constitutes a device? Is it like 10 or is it like 8,000?
Well, I lack constitution, so I don't know. I need Vito's testimony. Yeah, we all do, don't we? Vito's a task force. Vito did it.
Why do we not have the 2 most significant and relevant and important testimonies of all of the testimonies?
Keegan Kline fucking destroyed him. Dude, imagine getting owned by Keegan Kline, dude.
How do you not realize that you're getting owned by Keegan Kline? You're so desperate to solve the case that you get stupid. That's literally the only thing, the only argument that conspiracy theorists that we're making. Desperation leads to carelessness. It leads you to, like, your bias. You want something so bad, you're going to start being delusional about it. Like, yeah, surely this guy's telling us the truth. We're going to search the. Yeah.
Now, imagine, I totally agree, right? Now, what? I totally agree with the point that you stole from somebody else that you're making right now. I would never.
It was implanted in my head by a man with who actually knows things. Yeah.
Implanted it by a man. Yes. Oh, did they have like a red light in the? Oh, never mind. Okay, so so with this idea, like that he got cooked, like Holman and Vito got taken for a ride by Keegan Kline, who I don't even think had a license, to be honest with you. So imagine them like pushing, because you got to go to like your superiors, right? And you got to say, hey, we got a good one. You know, he could be the one. This is the guy.
We got to go dredge the Wabash for this one.
And they go, wait, that fat guy right there? He doesn't look like the bridge guy. Like, I think he would probably be in pain walking across the bridge. And they go, no. And they have to justify it, right? They have to say, and usually, like, you're not in front of the fucking grand jury. You know, it's a fucking lieutenant, it's a captain, and you're like gonna pitch your idea about the case to them, right?
Right.
So they're probably including shit that's like speculation. And like, you know, if we get a search warrant, we may be able to find this. And these are the things we have to get a search warrant. This is what we think could possibly be there. So they stretch, not necessarily like stretching the truth per se, but like, you know, it's not cross-examination. Like, they're gonna say whatever they can to their manager, their boss, leadership, to be able to get what they need for the next step.
Yeah.
Their moms, yes. Their moms are involved, I'm sure.
I know they are cooking dinner.
Yeah, they are cooking dinner. It's a little late, ladies. Come on, get to it. So in reverse, right? All of a sudden, you've said all these things that were not fact, that were not like independently provable to any degree of certainty about him as a suspect, right?
Right.
Then he falls out as a suspect. You can't use him anymore because he didn't do it. And you have like proof of that, and you have another suspect. So all of what you used to try to convince people, you can easily wash away and run away from and disassemble, because you were already thinking about the things you could have found if you were to complete the investigation on him as justification for pursuing him as a suspect. So like, they can erase and like just get rid of so much of the stuff they believed made him a good suspect, because it was never probably supported in any great measure, that it's not going to be cross-examinable, because the evidence about him is not going to be able to be at trial. So like they probably don't even believe that he could be, or they don't even believe that a lot of this stuff was like concrete. It could just be washed away once they get a new suspect, and it's not solid proof of anything.
The planet?
I love that fucking clip. The planet?
Can we Irish goodbye?
Yeah, bye.
You can stay on. I'll just
Bye,
listen.
mamas. One love. Hey, y'all be good now.
The moms are all asleep, TV. Oh, motherfucker. Okay, bye, friends. I'm going to